Good evening, friends. I'd like to call this meeting to order. Welcome to meeting 6 of the Special Joint Committee on the Declaration Emergency, created pursuant to the order of the House, March 2nd, 2022, and the Senate, March 3rd, 2022. Today's meeting is taking place in a hybrid format pursuant to the order of the House dated November 25th, 2021. I would like to remind all those present in the room to please follow the recommendations of the public health authorities, as well as the directives of the Board of the Internal Economy to maintain health and safety. Should any technical challenges arise, please advise me, as we may need to suspend a few minutes to ensure that all members are able to participate fully. Witnesses should also be aware that translation is available through the global icon at the bottom of their screen. We have with us today from the Department of Finance, Isabelle Jacques, Assistant Deputy Minister of the Financial Sector Policy Branch, Julien Brazeau, Director General of Financial Crimes and Security Division of the Financial Sector Policy Branch, Manuel Dussault, Senior Director for Framework Policy, Financial Institutions Division of the Financial Sector Policy Branch, and from the Financial Transactions and Reports Analysis Centre of Canada, FinTrack, we have Barry McKillop, Deputy Director Intelligence, and Donna Ashmoff, Deputy Director for Chief Compliance Officer in the Compliance Sector. Each department will have 5 minutes for opening remarks, and if we can, let's begin with the Department of Finance. The floor is yours for 5 minutes, please, for opening remarks.
Oui, bonsoir, Monsieur le Président.
Good evening, Mr. Chair, and thank you for the invitation to appear before you today.
Is Isabelle Jacques. I am the Assistant Deputy Minister of the Financial Sector Policy Branch at Finance Canada, and I'm here today to explain the measures contained in the Emergency Economic Measures Order. As you know, the order was adopted by the government pursuant to the Emergencies Act. It was in force upon its registration on February 15th until its revocation on February 23rd. The order was not retroactive. La première catégorie de mesures.
The first category of measures in the order required financial service providers to cease providing financial services to any individual or entity engaged directly or indirectly in activities prohibited by the Emergency Measures Regulations. The order referred to such an individual or entity as a designated person. The industry told the department that their actions taken in response to the order resulted in the freezing of approximately 280 financial products, such as savings and checking accounts, credit cards, and lines of credit, for a total of approximately $8 million, including $3.8 million from a payment service provider. We understand that financial service providers undertook these actions based on information provided by the RCMP in large part. The order authorized law enforcement agencies and other government institutions to disclose information to financial service providers to apply the order.
In addition, the order required financial service providers to determine on a continuing basis whether they were in possession of a designated person's property and to disclose to the RCMP or CSIS the existence of such property and any information they could have had about associated transactions. The measures in the order were targeted exclusively at designated persons, and financial service providers were required to resume providing financial services when a designated person ceased engaging in activities prohibited by the regulations. I also understand that financial service providers began unfreezing accounts, credit cards, and lines of credits on February 21st after receiving additional and updated information from the RCMP. All accounts frozen in response to the order had been unfrozen by February 24th. L'autre grande catégorie.
The other broad category of measures in the order was specifically aimed at crowdfunding platforms and payment service providers. that were not subject to the obligations under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act. The order extended certain anti-money laundering and anti-terrorist financing requirements, such as registration with FINTRAC and the reporting of suspicious and large value transactions to crowdfunding platforms and some payment service providers that were in possession of a designated person's property.
Reduce the risk that these platforms and payment service providers could receive funds from illicit sources and increase the quality of and quantity of financial transactions information received by FINTRAC, which would in turn make more information available to support investigations by law enforcement. Je vous remercie.
Thank you. It will be our pleasure to answer your questions.
Thank you very much. We'll now proceed with the opening statements from FINTRAC.
Je vous remercie, Monsieur le Président.
Thank you, Mr. Chair, for inviting FINTRAC to participate in your review of the Declaration of Emergency. I would like to begin by explaining briefly the Centre's role in protecting Canadians and Canada's economy. FINTRAC's mandate is to facilitate the detection, prevention, and deterrence of money laundering and the financing of terrorist activities.
Was established as an administrative financial intelligence unit and not a law enforcement or investigative agency. We do not have the authority to monitor or track financial transactions in real time, freeze or seize funds, ask any entity to freeze or seize funds, or cancel or delay financial transactions. This did not change under the Emergencies Act. As Canada's anti-money laundering and anti-terrorism financing regulator, we are responsible for ensuring the compliance of more than 24,000 businesses that have requirements under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act. Businesses subject to this act are required to fulfill a number of obligations, including reporting certain transactions to FINTRAC, such as international electronic funds transfers and suspicious transactions. With the reporting that we receive, we are able to generate actionable financial intelligence for Canada's police, law enforcement, and national security agencies. Last year, our financial intelligence contributed to over 376 major resource-intensive investigations and many hundreds of other individual investigations at the municipal, provincial, and federal levels across the country. Mr. Chair, under the Emergency Economic Measures Order, certain businesses were required to take specific actions in relation to the financial activity of individuals who were engaged in the blockades. For example, crowdfunding platforms and payment service providers were required to register with FINTRAC when they were in possession or control of property that was owned, held, or controlled by an individual or entity that was engaged in an activity that was prohibited in the emergency measures regulations. These same businesses were also required to report certain types of transactions when thresholds set out in the Proceeds of Crime, Money Laundering, and Terrorist Financing Act and its regulations were met. Following the invocation of the Emergencies Act, FINTRAC was contacted by a number of crowdfunding platforms and payment service providers to discuss registration. In addition to engaging in these pre-registration discussions, we also prepared guidance for businesses potentially affected by the Emergencies Act, and we modified our own IT systems to allow for the registration of these new entities. Given that it normally takes about 30 days to complete the registration process with FINTRAC, we did not have the opportunity to formally register any entities in relation to the Emergencies Act prior to its revocation. In terms of our role as Canada's Financial Intelligence Unit, I'm prohibited under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act from discussing any information that we receive or any specific financial intelligence that we disclose. What I can say, however, is that we were actively engaged throughout this period in fulfilling our mandate, supporting the money laundering and terrorist activity financing investigation of Canada's police, law enforcement, and national security agencies. I can also say that it was clear that businesses were very much aware of the Emergencies Act and the need to be extra diligent in relation to their anti-money laundering and anti-terrorist financing obligations. Thank you, Mr. Chair, and we are available for any questions that you may have.
Thank you very much to both presentations and opening remarks. I just would like to provide a preface that in these upcoming rounds, you may find from time to time that MPs or parliamentarian senators may interject to redirect you to another question. It's not that they're being rude, it's just that they have a very limited amount of time. And I'm stating that to be able to provide you the opportunity, should you not be able to answer a question in its fullness, to always be able to follow up in writing. And we're going to do our best to avoid scenarios where people are talking over each other, because as we found out in previous rounds, it really puts a lot of strain on the interpreters. To the folks around the table, I think that last meeting, it was made better by the chair when we had a acknowledgement of a minute left. So for the purpose of this meeting, I'll hold up this folder to indicate that you have a minute. I'm happy to do another one if you have it. I am certainly happy to do another one if you have it. But absent of that, the blue pin in the middle. What that does is just let you know that it's time to wrap up your remarks. And I'll just state that there will be discretion. If there is a fulsome answer being provided, I will, to the best of my ability, allow that question to end. If that's okay, we will proceed now with the opening round of 5-minute questions, beginning with Mr. Motz. Mr. Motz, the floor is yours.
Thank you, Chair, and thank you, witnesses, for being here. I will fire some rather rapid questions at you. Mr. McKillop, I want to know, first of all, your direction to investigate under the Emergencies Act was received by and given to you by whom?
We have no investigative powers.
Well, okay, I used the wrong choice of words. Who gave you the direction to pursue matters under the Emergencies Act?
The direction already existed in the Proceeds of Crime, Money Laundering, Terrorist Financing Act, sir, and that was not changed by the Emergency Measures Act.
Was there any evidence of money laundering in under the Emergencies Act that you found with the protests?
There was no money laundering per se during the emergency measures that I could see, but sir, the reporting would have been reported specifically on money laundering or terrorist financing.
Okay, so did you find any evidence of terrorist financing activities with the protests under the Emergencies Act?
While I can't speak to any specifics, I can't really disclose anything that we've disclosed in terms of specifics on any activities that may or may not have been taking place.
Yeah, I'm not asking for specifics. I'm asking whether you found any terrorist activities on it. And you've testified at another committee before that you said you did not. Did you find any evidence of insurrection funding activities by the protests or protesters during this particular Emergencies Act invocation?
Nothing that was reported to us, no.
All right. Ms. Jacques, you explained that you were looking for illicit sources of finances. What is an illicit source of financing?
Well, no, we were not looking for illicit sources of financing. What we did was put in place measures so that would help in case that they were illicit source of financing.
All right. Did your department consult with the DOJ, the Department of Justice, on the charter risks involving freezing the individual bank accounts without a court order?
Yes, we did.
And?
As you know, I'm not at liberty to provide legal advice that was provided to us, but certainly the emergency order became law, and
okay, so you can't. So did the DOJ express concerns with respect to Section 8 of the Charter, which guarantees protection against unreasonable search and seizure?
I cannot provide advice or detail of advice provided to us as clients. Well,
I would question whether you're a client. So it would appear to me you've been specifically instructed by either the PMO, the Minister of Finance, or the Minister of Justice to invoke solicitor-client privilege in response to these questions, or invoke the principle of cabinet confidence. Would that be an accurate statement?
No, that would not. I mean, I used to be a lawyer with the Department of Justice, and I'm aware of the boundaries with respect to solicitor-client privilege.
Did you think that the Emergencies Act order in council, which was invoked granted on the 14th of February, gave financial institutions the power to conduct unreasonable search and seizure?
No, I did not. In view of the scheme that was set up in the order, there was two manners in which financial institution could find information. One, information provided by law enforcement, RCMP, and the other, if they saw suspicious activities while using their own internal resources.
And it's interesting that I mean, banks can freeze assets in banks or in people's accounts with a judicial order. Is there a reason why that wasn't pursued?
Well, the provision.
Eh bien, la Cour provinciale a compétence pour cela, en vertu du code criminel, et le fédéral ne pouvait pas. Et étant donné l'urgence, la situation qui était quand même extraordinaire, il y avait quand même des troubles.
And I think I understand there's a technical difficulty. It looks like the French translation has gone to the English side and has vacated the French translation. Is that correct, Senator Carignan?
No translation.
Can we, I'm
I'm going to ask a question again. Can you hear the
OK,
translation?
là maintenant, oui. Yeah.
feel free to ask the question. When you finish asking the question, I'll start.
If she could repeat the last two sentences.
Yeah, he's going to get her repeat the whole response.
Oh, I'm not quite sure where I was at when I was interrupted.
Jacques, I'm going to allow for Mr. Motz to read.
Of obvious confidences. Now, did you, Ms. Jacques or Mr. McKillop, consult at all with the Privacy Commissioner on any of these matters related to the Order in Council, most specifically about Part C3, which required crowdfunding platforms and payment processors to report certain transactions to FINTRAC?
I did not.
Thank you very much. We will now move on to Ms. Bendayan for 5 minutes. The floor is yours.
Thank you. Just before starting my clock, can I just point out that there was a problem with translation which prevented the witness's answer from being translated? Has that been resolved?
I believe it has. I believe it was just a switch issue, but in the event that there is any disruptions on your end, please do, raise your hand and I'll stop the clock and allow for that to be fixed.
Mr. McKillop, I'll begin with you. Did FINTRAC freeze any bank accounts?
No, FINTRAC does not have the authority nor the power to freeze bank accounts.
Madame Jacques,
Ms. Jacques, did the government freeze bank accounts? No, the government did not freeze accounts. As you know, the order gave the responsibility to financial institutions to take action if they deemed it necessary. I'd like to quote Ms. Angelina Masson.
In English for her quote, she is from the Canadian Bankers Association, and she has testified before the Standing Committee on Finance on March 7th that banks relied on the names provided by the RCMP, but there were no obligations under the order separate from that required banks to make their own determinations, end of quote. Alors, si je comprends bien, c'est...
So if I've understood correctly, financial institutions were the ones that acted based on information from the RCMP. Is that correct, Ms. Jacques? I would say that in large part based on the information reported to us afterward, but I think most of the measures taken by the banks came from information received by the RCMP, but I know that some financial institutions took measures when they determined that there were suspicious activities, and they did the appropriate verifications, and I know that some accounts were frozen, independently of the information obtained from the RCMP. But I would say that that's not the vast majority. Based on what I was told, that wasn't the majority of cases.
Statement which read, at no time did they, being the RCMP, provide a list of donors to financial institutions. So perhaps I'll allow you or other witnesses to explain to the Canadians watching this committee exactly how determinations were made for the freezing of accounts.
Well, I can't tell you what the RCMP shared with the financial institutions, but certainly, as per the order, the onus was on the financial institution to look at their relationship with their clients on an ongoing basis and make a determination as to whether or not they should freeze assets or stop providing services to their clients.
Thank you. So it was the banks that made that determination. And in so doing, can you also explain to us, consistent with what the banks acted on, the government's intention in putting these measures in place? Was it to freeze the accounts of people participating in the blockades or the organizers of the blockades? Help us to understand that aspect.
Well, the intent was to stop the funding of illegal activities, or certainly curtail it. So that was the main goal. The second goal was also to dissuade people to participate in illegal activities on the Hill. So it had two goals.
Thank you. And I think that you've already clarified that it was the bank making those determinations, but can you point us to on what basis they would make the determinations? Is it on the basis of anything that we provided, or on the terms of their own conditions? I believe banks have terms of service. Madame Jacques, was it on that basis that they would do so, or on something else?
Well, they have terms of service. I don't know if I could say it was on those terms of services that they used, but what they had in their possession was information provided by the RCMP, and they would have, on top of that, they would also have to do their own assessment, because ultimately they had to make the determination to cease providing a service to a customer, so basically to freeze accounts. But they could also use their own internal programs and surge capacity to determine whether they were suspicious transactions that met the definition of the order.
Thank you. I would just like to pick up on something my colleague raised earlier. Mr. Moss was pointing you to search and seizure provisions in the Charter. Was anything seized as a result of the bank's actions, or are we talking about freezing? And is there a distinction in your opinion?
Briefly,
Yeah, there's
please.
there is a big distinction. Yes, there was no seizing of asset. They were frozen.
Thank you very much. We will now move on to Monsieur Fortin for 5 minutes.
Merci, merci, Monsieur.
Thank you, Mr. Chair. Thank you to the witnesses for being with us today. I'll pick up with Ms. Jacques. Ms. Jacques, you've just mentioned that accounts weren't seized, they were only frozen. Can you explain the distinction you make between a frozen and a seized account? Yes, I think first we have to look at Clause 2 of the order. What it says is that financial service providers must cease making available goods like virtual money to a designated person. So it was an obligation to cease operations. So the funds were no longer available. They weren't seized, but they were frozen. So what is a seizure if it's not freezing funds? Well, in my opinion, seizing is when a creditor takes an asset belonging to a debtor. So here, it's not a creditor trying to be reimbursed. The bank hasn't taken the money for a creditor. It only froze the funds or made them inaccessible during the period during which the person was participating in illegal activities. Okay. I understand. I'm not sure I have the same definition of seizure, but I understand your point of view. So, Ms. Jacques, how did it happen? You say that the government seized or did not seize any accounts, but you say financial institutions did freeze accounts. So was there anyone who gave instructions to financial institutions? I imagine it wasn't done randomly, freezing the accounts of someone because they're on the Hill. What was the process? Were you in discussions with financial institutions? How did that break down? The order was made. It was made public. Given that the situation was out of the ordinary, We communicated with different representatives from the financial sector, the Canadian Bankers Association, Desjardins, and other associations, so they could ask us questions regarding the process they could follow. So we discussed that with them. They knew that they were responsible for making decisions, that the RCMP could share information with them, which the RCMP did, and that they had an obligation to continue assessing their relationship with their clients to ensure there would be no person or entity using funds illicitly. But you or did someone from your office give instructions to a financial institution to freeze or seize any accounts? No, never. No instructions were given in that regard. Were you told of frozen accounts? Yes. How often did you receive reports of those operations? At the beginning, of course, it took a few days, but after a few days, the Canadian Bankers Association was reporting every day, at the end of the day, of accounts that had been frozen by institutions. Is it possible to share a copy of those reports with us, Ms. Jacques? I will try to see if I can share that with you. I need to inform myself. Are you talking about authorization? Yes, authorization. Well, given that our committee has to review the exercise of the measures, I imagine we'll need to see what measures were applied. So I'd like to know the name of the people whose accounts were seized or frozen, the amounts frozen, the dates when they were frozen, and the dates when they were unfrozen, and especially the reasons why the accounts were frozen for those individuals. So I imagine I'll have that information. Well, just to specify, the type of information we had was aggregate, so we didn't have any names nor the type of account. What we had was the number of financial products and the amount of money. But we didn't have any details. We didn't have the names of people. None of that information was made available. Thank you.
At this point, I'm going to pass the chair virtually over to Senator Boniface. If you could please set a 5-minute timer, then I'll proceed with my questions.
Okay, let's turn to Mr. Green. 5 minutes, sir.
Thank you very much, Senator. I'm going to begin my questions for FinTrack. We've heard, I think, some interesting testimony early on that provides a little bit of contradictions from previous testimonies of other witnesses. So I'd like to begin by asking, did you observe any red flags prior to the invocation of the Emergency Act on the financial transactions occurring around the occupation and the blockades?
Thank you for the question. Sir, we receive reporting on a regular basis from a number of reporting entities related to suspicions of money laundering and or terrorist financing. We did over 2,000 disclosures last year. So on a daily basis, we disclose to law enforcement and our national security partners on individuals or entities that may be linked in terms of their transactions to potential money laundering or terrorist financing. So we would have disclosed on individuals in that case. We do that on a daily basis. That is our mandate, and that is what we continue to do before, during, and after the Emergency Measures Act.
For the witnesses, you will hear me say thank you from time to time so that I can reclaim my time and continue with the questioning. So to be clear, out of the 280 frozen accounts, how many of them did you flag as being suspicious in financial activity prior to the invocation of the Act?
That is not within our mandate, sir, to flag those to anybody in terms of flagging them to the financial institutions. That is not within our mandate. Madam Chair, then who would you be reporting this to? Okay, ostensibly you would be receiving these reports as you've testified. You'd get the information. To whom would it go? If I had a suspicious transaction report that I received, and if it met my threshold to suspect that it would be relevant to a money laundering or terrorist financing investigation, I would disclose it to law enforcement.
So
whether
my
it's a local law enforcement or RCMP.
My question through you, Madam Chair, to Mr. McCaleb, which instances did you flag prior to the invocation of the act that would have been deemed suspicious? And to whom did you report, the RCMP or local police or the Provincial Intelligence Task Force? With specificity, please, sir.
We would have simply fulfilled our mandate, Madam Chair, in terms of disclosing any suspicious activity that we deemed relevant to money laundering and terrorist financing, and it
Mr.
would have been
McCaleb,
to whichever police force.
Thank you. Respectfully, I'm asking a very specific question, and I'm not getting a response that's adequate to the nature and the seriousness of this committee. And I would ask you to disclose, please, given the mandate that you have now stated multiple times leading up to this, which red flags did you receive and report on to law enforcement?
Madam Chair, with respect, the member is asking whether or not I flagged red flags to somebody that led to the questions to Madame Jacques about seizing bank accounts
That's
and
not what I
identifying
asked.
bank accounts.
You've extended that question. I asked a very specific question, sir.
Well, I'm not at liberty under my legislation, sir, to give you specificity on to whom I disclosed or what I disclosed.
What was the nature of your communications between your agency and the RCMP?
We have communications, Madam Chair, on a daily basis with the RCMP.
Were you in communication
relation
prior to the declaration of the emergency regarding suspicious activities of financial transactions related to the occupation and blockades?
Madam Chair, FINTRAC's mandate does not extend to the development of the Emergency Measures Act. We were not involved in that, nor in discussions on the Emergency Measures Act or the regulations and their creation.
So we have Section 4 of the order, which also implements a reporting obligation that those entities for suspicious financial transactions and states, and it lists in Section 2 that there's a report to the center of every financial transaction, and then it has two subsections, A and B, and then some more information around money laundering and terrorist financing regulations. So again, for the fourth or the fifth time, how many transactions were reported under the order after the invocation?
Madam Chair, I'm not at liberty with my, unfortunately, under my legislation, I cannot disclose anything specific
Madam Chair,
in
through
terms of
you,
numbers.
is the member aware of the constitution of this committee, and would it help them if we invited them back and perhaps created an in-camera scenario? We've all been sworn in to provide for the clarity of this committee the nature of FINTRAC's role in this. Was this something you'd be willing to discuss if we had to move in camera at a future date, sir?
Madam Chair, with all due respect, even in camera, I'm limited by my legislation what I can and cannot say. We fulfill our mandate. We did disclose any suspicious transactions as I normally would to the RCMP, whether
Mr.
or
McKillop,
not.
I'm sorry, I'm going to have to cut you there. Thank you.
Thank you, Madam Chair, and I'll at this take back the chair. And we will continue with yourself, Senator. You have 5 minutes, and the floor is yours. Senator Boniface?
Thank you very much to all the witnesses for being here. And I just want to perhaps give an opportunity for Mr. Particularly from FINTRAC, to help the committee understand your relationship with respect to the emergency order. So we've heard where you don't impact and how you're not affected. I'd like to just understand better what was the role of FINTRAC during the emergency order.
Thank you for the question. FINTRAC's role under the order did not change with respect to our mandate and the role that we normally do prior to the order and subsequent to, from an intelligence perspective. From the compliance side, it added crowdfunding platforms and payment service providers and required that they register with FINTRAC as reporting entities. And that pre-registration did in fact take place. As I mentioned in my opening remarks, the registration process did not complete during the time that the emergency orders were in effect. But from an intelligence perspective, all reporting received would have to be received only based on money laundering or terrorist financing suspicions by our reporting entities. So we did not have any extended powers or enhanced authorities from a financial intelligence perspective at FinTrack because of the orders.
Okay, thank you very much. And perhaps I could ask you to, both for finance and FinTrack, as you work through this process, which is unprecedented, have you conducted any internal reviews that would help give you insight into how it worked, didn't work, and what you may have learned from the process? I'll go to finance first.
I mean, we did not do a formal a review, but certainly we've thought about it. We had some comments were provided by some institutions, and they would have liked to have been or contacted maybe earlier. We moved as quickly as we could under the circumstances. The situation was unprecedented. We tried to go to the larger financial institution, including Desjardins, and we also extensively contacted certainly the Canadian Credit Union Association. We did our best, but I think some of the institutions would like to have been contacted earlier. So that's something we would seek to improve in the future.
And from FinTrack's perspective?
Thank you very much. From the financial intelligence component of FinTrack, there was no review of anything that was done in the sense that our mandate has continued, and we just continued. I think some of the lessons learned, the outreach, and some of the new entities and new sectors that we had an opportunity to talk about, perhaps Ms. Achimov could explain to you what that outreach was and how it might position us for the future.
Thank you, Mr. Chair. I'd like to say that we took every opportunity in having preliminary discussions. We had a number of calls and queries from those who weren't quite sure if they fell under the auspices of what was required. So we answered questions, and what we tried to do is target outreach and be able to be consistent in what we knew at the time. Keep in mind that it was a very short period of time, and we had, as my colleague Mr. McKillop had indicated, 21 potential payment service providers and crowdfunding platform service providers who reached out to us.
Okay, and perhaps back to finance, if I can ask the question, to actually put this in place, how long were you given to put the system in place? So obviously you were giving forewarning, the invocation was coming. How much time did you have?
Oh, we're talking about days. So it was very quick, and as such, once the order came into force, we had very little time to try to help all the institutions that had to take action. So we moved as quickly as we could.
I appreciate that. Mr. Chair, is my time up? I'll leave it there then. Thanks.
My apologies. When I bring it back down, it's that I've noted that you've seen it. So we will now move on to Senator Cagnon for 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question is for Ms. Jacques. If I've understood you correctly, I have the order before me, the Emergency Economic Measures Order. If I've understood you correctly, you're saying there was no seizure because it's not the government that seized, it's the banks that decided themselves to freeze accounts of designated persons. Is that what you're saying? Very seriously. No, that's not what I said. What I've said is that Section 2 said that financial service providers had to cease making goods available, money, for example, to designated persons, funds or virtual currency. So they had to cease providing services. Yes. Not to seize goods. There's nothing in the law that says goods must be seized. It's that they have to stop making goods available. It's a preservation order. So that's also called seizure. No. Well, there are two types of seizures. I've understood you talk earlier, I'm not interested in your lessons in law. Well, listen. No, seizure is not about creditors. I'll send you Supreme Court citations. I've understood. I'm not here to teach law. I was trying to answer questions. I know. It's not a seizure.
Excuse me.
The law says we have to see. I understand.
Minute, and I'm going to ask that questions go through the chair. We will respect the fact that the committee time allotted to each parliamentarian is their time to redirect on questions. So we'll ask that you please answer the questions that are asked to you, given the seriousness and the nature of this committee. You're at 1 minute and 53 seconds. You still have roughly 3 minutes left in your rounds.
Merci, Monsieur le Président.
Thank you, Mr. Chair. But the obligation to preserve the goods comes from the order. Do we agree on that? Yes. Okay. Who advised the banks that designated persons, the names of the designated persons, did that come from the people who were present on the Hill, who were in the gatherings? Because I wasn't a designated person. So was there a criteria then to choose the designated persons? Who chose the designated persons? I know there's information that was shared by the RCMP with the banks, but it was the banks that had to ensure, by reading the order with the information that they had to decide. So if they had the goods of those people. Okay. As in the case of any seizure, when there's a seizure by a judge's order, here it was through the order. My question will now be for FinTrack. For financial services, under 4.2, the banks or financial institutions had to report to the center every financial transaction that occurs or that is attempted in the course of their activities and in respect of which there are reasonable grounds to suspect that the transaction is related to the commission or the attempted commission of a money laundering offense by a designated person or terrorist financing. That type of offense, that type of reasonable grounds to suspect, was that reported to you?
Merci pour la question.
Thank you for the question. It hasn't changed the reason why suspicious transactions have to be reported. It had to be related not only to the convoy or what was happening. It wasn't the activity as such. They could only report to us suspicious activities if there was a reason to believe that it was connected to money laundering or terrorist activity financing. So it wasn't just because the person was in Ottawa. That wasn't enough. So for the designated persons, are there any who were reported as being reasonable grounds to suspect that they committed money laundering, for example, or terrorist activity financing? I couldn't tell you, Mr. Chair, given that we did not receive the list of designated persons. The list of designated persons was provided to financial institutions, not to FinTrack. So I'm not aware of that. But to your knowledge...
My apologies, sir, in the pause. I didn't put up the 1 minute, but you are at 5 minutes, and you got a little bit extra there given the interruption that I had. Thank you. We will now move on to Senator Harder for 5 minutes. Senator Harder, the floor is yours.
Thank you very much, Chair, and thank you to the witnesses for appearing before us. I want to pursue some of the questioning that my colleague, Senator Boniface, began with. First with Isabelle Jacques. Could you tell us when in the sequencing of events you were asked to develop the regime which became the financial measures in the Emergency Measures Act?
Well, I found out the weekend of, well, I think it was Saturday the 12th, that the emergency order would be invoked.
And can you tell us which organizations were, in a sense, requesting of finance to develop the financial measures because of the circumstances that were before us?
Well, there were no organizations, but certainly in view of that requested it, but in view of the circumstances, we were contemplating what could be done to help the situation.
Right, but this wasn't you sitting at your desk looking at the screen and seeing what was happening on the street. I presume that there was an interaction with the department at the senior level, with police and other organizations who were looking at the options as to what measures could the government undertake. Is that correct?
Well, for the financial measures that are covered, the economic measures that are covered by the order, certainly I had discussions with the Deputy Minister at Finance.
And can you tell us the extent to which the Department of Finance engaged in consultations before the order came into effect with the financial institutions that would ultimately have the enforcement role and with the RCMP?
Unfortunately, I was not involved in any of those consultations, if there were any.
Was that the Deputy Minister's prerogative?
I would not be able to tell you. I do not know who was involved at what moment. All we know is that when we found out that the emergency order would be invoked, we certainly worked to develop measures that could be taken.
So I suspect that this will be an area of inquiry with the minister, and hopefully Mr. Sabia will join the minister when she appears. My next question is, after the invocation of the Emergencies Act, what kind of outreach did your department undertake to the financial institutions to both respond to their questions and to give them guidelines as to how you expected the enforcement to take place, and how were the relationships between the financial institutions and the RCMP developed?
Well, independently, after the order came into force, we reached out to some of the larger financial institutions. As I mentioned before, in Desjardins, we also reached out to specifically the Canadian Bankers Association so we could help centralize some of the questions they may have. We're trying to help them understand the order. We reached out to the Canadian Credit Union Association, the Canadian Life and Health Insurance Association, and the Insurance Bureau of Canada.
And did, in that outreach after the invocation of the Emergency Act, did they offer any views with respect to how the financial aspects of the emergency declaration could be better tailored to enforcement action?
I don't recall any such discussions. I may turn to my colleague Julien Brazeau just to ensure that we give you a complete answer.
I don't recall any such sort of comments that were made by the FIs themselves. No.
Thank you.
Senator Harder?
I thought my time had expired.
Oh, no, you still have 30 seconds.
Okay.
I'll redeem another 10 seconds.
Okay.
Would it, just for the purpose of the committee, would it be helpful that I keep this up until it comes down and do the old drop as it ends, or what?
Sure.
All right. I don't want to be tricking anybody out of their time here.
Yeah.
Okay, Senator Harder, you have 30 seconds left.
Thank you. To Barry McKillop, it's clear from, if I interpret your testimony correctly, that the crowdfunding organizations and payment service providers were not part of your mandate before the events on the Hill, and they were added to your mandate at that time. Was that a gap in your view, and should that continue?
Thank you for the question, Mr. Chair. It was a gap in the sense that they are not covered as a reporting entity. I think the jury is still out. It's new, and I think that once they do, if it does become permanent, and it was announced that it would become permanent, that we will learn as we go on in terms of what type of reporting we're going to see. I don't know the extent of reporting that we would see from them, so I think it's something that we will learn together as we move forward. Certainly, I do believe that having them subject to the Proceeds of Crime, Money Laundering, Terrorist Financing Act would at the very least act as a deterrent for anyone who might want to use a crowdfunding platform to advance nefarious activities. So I believe that it will have at least that effect. The type of reporting, because our threshold reporting is $10,000 or more in or out of Canada. The transactions within Canada we would not see unless they were suspicious. So I'm not sure what type of reporting we'll get, but I think the jury is out, and we look forward to it any way that we can attempt to reduce the opportunities for people to use these in a nefarious way. I think is beneficial.
Thank you. Thank you very much. We will now conclude the first round with Senator White. Senator White, the floor is yours.
Chair. Thank you very much, Mr. Chair. My question for Assistant Deputy Minister Jacques, if I may, you spoke to information provided to financial institutions that would allow those institutions to not permit the accounting and for the accounts or the financial assets to be accessible by certain individuals. Was that list produced solely by the RCMP, or was it produced also with assistance from your office?
Only by the RCMP.
You also, thank you, and you also stated that when the information would come back from those financial institutions at the end of each day, and that there would be an assessment done. I don't understand exactly what that assessment was, and are you referring to an assessment by the RCMP as to whether or not it's an account they want it to be kept inaccessible?
No, I think that, as you saw in the order, the financial institution had to report back to the RCMP directly. What we received on a daily basis was simply the aggregate amount of accounts frozen. Just the amount. We did not know who. We didn't have any names. And the number of products, financial products, whether, so in my opening remarks, I explained that there were, to our knowledge, as explained to us, 280 different products that were frozen.
When we say products, we're referring to accounts, right, or financial?
We're referring to, yes, accounts. So it's possible that one person has 3 or 4 different types of accounts.
So we had 200, thank you very much. We had 280 quote-unquote accounts for 280 or less people or individuals or organizations that we provided to the banks. The banks made a decision whether to not allow them to be accessible. They would then report back on how many they have quote-unquote frozen, because it's easier, each day, but there was no correlation between those names and what was frozen by your institution.
Well, the way it worked, it's slightly different. The RCMP would provide names to the financial institutions. They would do their internal review and also did on an ongoing basis looked at their accounts. So either based on the information provided by the RCMP, which I understand was largely the source of information, and their own internal review, they froze accounts.
Okay, so to be clear, only because I see a placard coming up in a minute or second, just to be clear, was there any point in time where the RCMP would state they don't need to be frozen and would actually release those accounts?
No, but I know at one point in time, certainly as of the February 21st, you saw that accounts started to become unfrozen. So I presume that there was information provided by the RCMP to the financial institution, potentially, and I don't know this, but could say a certain individual is no longer participating in illegal activities. So there's something that led to the accounts being unfrozen, but I don't know the exact nature of that information because I wasn't privy to it.
If I may, do you know if any criminal charges have been laid in relation to those accounts or the funding that was in those accounts?
I have no knowledge to that effect, no.
Would the
Not to my
RCMP
knowledge.
notify you if there were?
No, they would not.
Mr. McKillop, sorry I missed you. Do you know if any charges have been laid in relation to any of the information you provided the RCMP?
I do not, sir.
I'm done. Thanks.
Okay, thank you very much. We are now into our second round, which will be 4-minute rounds from the government side and the opposition side, followed by 3-minute rounds. Sorry? Is there a question?
I'm just wondering, since we only have this panel and we've got 3 hours, could we just continue with 5-minute rounds? Is that amenable to the members of the committee?
Do you want to move a motion to that effect, Mr. Verney?
Yes, I would move that we continue with 5-minute rounds in round 2 and in round 3. Thank you.
All agreed? I think we have unanimous consent. Anybody dissenting? So we will do that. Thank you very much. So we now have a 5-minute round for Mr. Varani. Mr. Varani, the floor is yours. My apologies. There it is. My apologies, Mr. Brock. The floor was yours. Thank you, Mr. Brock. You've just been given an extra minute.
Thank you, Mr. Chair. And thank you to all the witnesses. I want to start with Mr. McKillop. Mr. McKillop, am I correct that this appearance today would represent your third appearance at various committees over the last several months?
I believe that is correct, Mr. Chair.
And that would be finance. You testified at on the 24th of February, and public safety. I don't know if that was pre-finance or post-finance, but it was probably in the month of February as well.
Mr. Chair, I do not recall the dates, but you are correct. It was both the Finance and Security Committee.
And following your testimony at both of those committees, was there a debriefing session with you and any member of the government? And what I mean by that, I'll be very specific. Did you have any conversations with the Prime Minister? Did you have any conversations with cabinet ministers, specifically the Deputy Prime Minister, Minister of Finance, Minister of Public Safety, Minister of Justice, Minister of Emergency Preparedness, or quite frankly, any member of the Liberal caucus? Did you speak to anyone post your attendances?
I did not, Mr. Chair.
Thank you. Now, I'm going to ask you for the third time questions that were put to you by my colleague, Mr. Motz, and my colleague, Mr. Green, that you seem to have some difficulty responding with clarity. So if there's any confusion in the way that I phrase this question, please ask for clarification. I'm more than happy to try to simplify the question because I'm hoping I'm going to get a straight answer. To Mr. Motz's question, with respect to the 280 financial products that were frozen, and I appreciate your legislation that you're governed by prohibits you from giving us specifics. But the question I'm asking you is not specifics. The question I'm asking you is, upon your review or anyone working under your command at FinTrack, did you uncover any evidence of terrorist activities or money laundering?
Thank you for the question, Mr. Chair. I will try to answer this as completely as I can, bearing in mind, without providing specifics, the reference to the 280 financial products. I do not know. I do not have a list of those individuals. If a reporting entity, a financial institution in this case, knew of one of these individuals or had one of these as designated, and in their review of the person's transactions and historical transactions, they suspected that some of their historical transactions would have been related to money laundering or support for anything else in terms of terrorism, then they would have reported an STR to me. I would not necessarily know, and I would not know that it came because of the designation per se. The financial institutions do adverse media reviews on all their clients on a regular basis, not necessarily linked to the convoy, but on a regular basis. Adverse media reviews are done as one of the tools that they use to identify people that they
Mr. McKillop,
may want.
You're not answering the question. You're not answering the question. With due respect, you're not. So I'll be more specific now. From February the 15th to February the 23rd, did your department receive any information from any financial institution in this country of any evidence of money laundering or terrorist activities? Yes or no?
Yes, we receive about 9,000 STRs a week, sir.
I'm asking about the 15th of February to the 23rd in relation to this particular act, the Emergencies Act and the order by which the financial institutions were required to report. Did they report terrorist activities or money laundering? Yes or no?
Mr. Chair, they would have reported money laundering or terrorist financing on individuals, not necessarily, they may have been involved in this. They may have been individuals involved in this convoy. The money laundering per se or the terrorist financing per se would not have been directly linked to the convoy. However, there may have been individuals who were in the convoy, who were identified, who were in the newspapers, that would have been historically through transaction monitoring, may have been identified as having committed potential money laundering activities or money laundering type activities that the institution would have reported. And during the week of February 15th to 23rd, during that period of time, we would have received somewhere around 9,000 STRs, some of which may have involved individuals that were in Ottawa, but it was not, there were no convoy per se related money laundering. The convoy itself was not an event that was used to launder funds. It was an event where funding was provided to support the convoy in advance of it being declared illegal, at which time any transactions to support would have been frozen and disallowed by the financial institutions.
Thank you. And just for the note of the committee, I did allow that final question to be answered. It was, I think, an important question. We will now go on to Mr. Varani, who also has a 5-minute round. Mr. Varani, the floor is yours.
Thank you. I'll direct my questions to Ms. Jacques, and I've got many questions, so I'd appreciate somewhat brief responses if possible. So the economic measures order that we've been discussing at length for the last hour applied nationally, correct? Not just to Parliament Hill?
Correct.
Okay. And when we've been talking a great deal about accounts being frozen, when accounts were frozen for a 9-day period during the invocation, in whose custody did those assets reside? Did they remain with the financial institution that may have had them?
Yeah, they remain where they were. They were simply not accessible by the owners.
Okay. And you'd indicated that there were 280 products frozen, but that could have been less than 280 individuals because I could have had 4 accounts that were frozen, for example. Okay.
That is correct.
And you said that they would have been unfrozen either because the designated person was no longer designated, so the person packs up and leaves the blockade at Windsor or the blockade in Ottawa, or when the invocation of the declaration expires. That's correct?
That is accurate.
Okay, so at the most, these things would have been frozen for at the most 9 days, unless they were frozen somewhat earlier, but that's the bank acting on its own volition. Is that correct?
Yes, we understand there were orders that existed prior to the order coming into force.
Okay. And do you know how many such orders there may have been, just approximately, prior to?
I don't recall. I know there was at least one Ontario court order, but I do not recall.
Okay. And there's an obligation under the economic measures orders, sort of saying any entity, duty to cease dealings, and you've talked about this duty, that's section 2.1. But if the RCMP gives information on a hypothetical John Doe to CIBC, CIBC then takes a decision whether to freeze the assets of that John Doe, yes or no. But if CIBC chooses not to freeze the assets, were there any penalties or any consequences for CIBC for not doing so?
No, there were no penalties, and your statement was accurate.
Okay, thank you. And you mentioned at the outset that 280 products were frozen and that the value of such products was 8 million. Did I hear you correctly?
Yes.
Do you have any sense of how much in total was fundraised for illegal blockades in this country? Like I heard anecdotally roughly in the order of 20 million odd. Do you have any sense of that number?
I do not, but I can certainly turn to my colleague, Julien Brazeau.
No. Any sort of broad figures, we're relying on sort of media statements, but the only numbers that we received were accounts frozen by the financial institutions themselves.
Okay, and do you have any sense of how many people there were that were donating to various illegal blockades around the country?
I do not
have
that number.
Okay, thank you. And in terms of the impact of these measures, can you give us a sense of your evaluation? I mean, a lot of talk has been given into the economic measures and how it was designed, et cetera. But I've also understood, I think, from your testimony today and from what I've read, that simply the threat of the possibility of some of these freezings occurred dissuaded people from participating in illegal activity. Is that a fair statement?
Yes, it is.
Okay.
But I mean, and we heard, and again, you'd have to verify with the RCMP that reports were made that certainly some people did not show up on the Hill because they did not want their account to be frozen. So it did dissuade people. And I think the other impact was the $8 million frozen that did not go towards illegal activities.
Okay. And in terms of sort of the illegal activities, I was curious about one aspect because we've talked a bit about what Ontario did, what the city of Ottawa did or attempted to do. And one thing that Premier Ford attempted to do in this province was to address the Ontario plated vehicles. And he had jurisdiction over Ontario plated vehicles. But I noted that in my review of the economic measures order, obviously it's a national order and it dealt with things like insurance provisions. So was that a tool that allowed the measures to be taken vis-a-vis insurance companies such that if a car was registered in Alberta or BC or Saskatchewan, as the case may be, or whatever province other than Ontario, economic repercussions could follow vis-a-vis the owner of that vehicle and because it was registered in a different province, likely insured in a different province?
It could have occurred, certainly. I mean, insurance companies were asked to cease providing services. So it would be possible that, under the order, insurance could have been suspended for those people participating in the illegal activities on the Hill. But I'm not aware of any such occurrence. I'm not aware of any insurance being suspended.
Was the threat of insurance being suspended sufficient to dissuade some people with vehicles registered?
I think it did because people, it's their livelihood. I mean, some of the truckers on the Hill, I mean, they use their trucks to work. So I think certainly that was a dissuasive effect.
Okay, thank you, Missy.
Thank you very much, Mr. Varani. We will now move on to Mr. Fortin. Monsieur Fortin, you have 5 minutes. The floor is yours.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question will be for Ms. Jacques. The question was asked a number of times, but I'm not sure I've heard a clear answer. The order talks about designated persons. The question was asked to you and to Mr. McKillop. Who designated those people? I thought I understood it was the RCMP, but it's not clear to me who made that list to say whose accounts will be seized, frozen, or whatever. I understand your question. There was no list designating people. There was no list. Then how were they designated? How can a financial institution know that Réal Fortin is a designated person and his bank account will be seized? That's a good question. Of course, there was information provided by the RCMP to financial institutions. So based on that information, the bank did the necessary work to determine whether it met. Okay, the names submitted to financial institutions by the RCMP. Do you have a list of those names, Ms. Jacques? No. Okay, so with your permission, I will go to Mr. McKillop. I'll ask the same questions. Mr. McKillop, in your case, in your opinion, is there only the RCMP that designated persons to financial institutions for seizure? Thank you for the question, Mr. Chair. I believe the RCMP took on a coordination role. Who designated the people, Mr. McKillop? I'm sorry, we don't have much time. Who designated the people? I think it was any police body that could designate people. But I think the RCMP coordinated the list given to financial institutions. But that would be a question that would be better asked to the RCMP. Thank you for the advice. I'll be sure to follow up. Mr. McKillop, do you have a list of those people who were designated for seizure or frozen bank accounts? No. Thank you. Ms. Jacques again. Ms. Jacques, you said earlier that you'd received lists from financial institutions on a regular basis. You say there weren't any names, but there were the amounts seized. So I'd like to know, how many lists did you receive in relation to the order? I'd have to go back. I don't know. Based on my memory, based on the number of days, it was a short time, maybe 6. I can get back to you with the answer. Okay, I'd like that. But about 1 per day. So if you say 6 based on the order, yes, but at the beginning we didn't have any. In the first days, we didn't have a list. But as I've said, it wasn't a long list. It was the amounts and the number of accounts. So the amount frozen and the number of accounts. Yes, the total amount. We had no idea of the number of separate accounts. Let's say 13 accounts worth 1 million. So that's each financial institution that sent you a report like that. No, we received it through the Canadian Bankers Association. So Desjardins is not a member of that? No, Desjardins also provided the information separately. I think once. I'd like for you to look into that, Ms. Jacques, and provide that. Yes, I don't want to give you false information. Yes, I appreciate that. Thank you. Ms. Jacques, another question. What did you do with those reports? Those reports were shared, of course, internally with the deputy minister. And there was aggregate data. I don't know if we shared it beyond that. Julien? Yes, aggregate data was shared with the Treasury Board as well. The Privy Council, rather. The Privy Council that aggregated information based on what was happening with the emergency measures. So if there were no names on those lists and we don't know how much money was in each account, what was the point of aggregating it? It gave an overall sense of the scope of the amounts that were frozen and the total number of accounts that were frozen. Who had surveillance to know if these seizures were justified or not? Ms. Jacques? There's no verification that was done. Financial institutions acted in good faith. You're certain of that. Why? Pardon me? Why are you certain of that? I don't call that into question, but you seem so certain. What I mean is that we didn't do any follow-up to ensure. So that wasn't important. You assume that the banks. Thanks. Thank you, Ms. Jacques. I didn't say it wasn't important, but you didn't do it.
Thank you.
Okay.
That concludes that intervention. If I could now pass the chair on to Senator Boniface for my 5-minute round.
Mr. Green, you have 5 minutes. Please proceed.
Thank you very much. Madam Chair, through you back to Mr. McKillop, I think all witnesses, in fact, everybody tuning in tonight can see where there is some confusion around the roles of the various actors within the invocation of this act. We've heard about designated persons. We're trying to figure out who is responsible ultimately for designating these people. We're talking about the compilation of lists. This is a very serious committee. And so through you, Madam Chair, to Mr. McKillop, would you have been briefed on the charter breach analysis and the seriousness of the Emergencies Act under Section 4 and the orders that were granted through that act onto FinTrack?
No, Madam Chair, we were not involved in any of those discussions.
So, Mr. McKillop, is it your testimony here tonight that for the first time in the country's history, the government enacts the Emergencies Act, FinTrack is named in it under Section 4, and you had no legal parameters or briefings from the government as to the seriousness of this act and to what the roles would be as outlined in Section 4? Is that your testimony here tonight?
That is correct, Madam Chair. I was made aware of it perhaps a day before it went public, that we were briefed on this, but not in the development of this.
Sure. Madam Chair, I will state for the purpose of this committee that it has been my opinion and observation through the testimony of the witness that he has equated this to much of the regular transactions that go through FinTrack. And I started to talk with specificity around Section 4 of the order, which implements a reporting obligation for those entities with suspicious financial transactions. And the order states that those entities must also report to the center every financial transaction that occurs or is attempted in the course of their activities in respect in which there are reasonable grounds to suspect a transaction is related to the commission or attempted commission of money laundering offense by a designated person, or B, that the transaction is related to the commission or the attempted commission of a terrorist activity financing offense by the designated person. So for the clarity, under Section 4, Mr. McCallop, the center refers to FinTrack. Is that correct?
That is correct, Madam Chair, and the reporting is with respect to money laundering and or terrorist financing suspicions. That is the same level of suspicion on which reporting currently happens and has happened historically. What it did do is it indicated that there are individuals at the RCMP could have identified as designated with respect to this.
Madam Chair, thank you. I'm going to reclaim my time. Just for clarity, this is Section 4 of the Emergency Economic Measures Order. This is not just pertaining to your mandate, which also talks about to facilitate the detection, prevention, and deterrence of money laundering. This is the Emergency Economic Measures Order, which reporting would have had every transaction. And so where I'm stuck is in some of the contradictory testimony that we've heard today and previous testimony from the RCMP around whom is reporting to whom. As I read this piece of legislation, Madam Chair, through you to the witness, I'm to understand that all the entities that have registered with FinTrack would have reporting mechanisms on every financial transaction. And I have to state how unsettled I am that given the nature of this, because I believe there was a threat, that there doesn't appear to be any actions taken by either departments on briefings or debriefings or reflections on the seriousness of these orders, and that there doesn't appear to be any testimony here tonight that FinTrack actually knew or was a part of or understands that the reporting that came back to them for every financial transaction would have occurred there. So, Mr. McCallop, I'll give you the opportunity this last time. Did your center provide any heightened level of care and consideration for the powers granted to you under the Emergency Act order of this country respecting the transactions that were reported to you?
Madam Chair, just to be clear, our mandate with respect to the reporting, it's not every transaction that gets reported to FinTrack. FinTrack does not monitor every transaction in Canada. We don't monitor transactions regardless under the EMA, under the emergency measures. It did not increase our mandate. It increased people who would report to us, or entities such as crowdfunding platforms who could now report to us. They could still only report to us under
Mr. McKillop, I'm going to have to cut you off there. I've been generous with the time for Mr. Green.
Boniface, I appreciate your generosity. We will now move on to, we're going to repeat the first round. So Senator Boniface, the floor is yours for 5 minutes.
Thank you very much, Chair. And Mr. McKillop, and this may give you an opportunity to expand on what you were going to say. But in response to Mr. Brock's final question, and I want to make sure I got the response correct, you indicated that the convoy wasn't used for money laundering purposes, but you didn't mention the terrorism financing side of the equation. Based on what you're able to tell the committee, and I understand that there are limitations, was there any indication of terrorism financing noticed in the roughly 9,000 reports sent to you from financial institutions during the invocation of the order?
Thank you for the question. There were, out of the 9,000 STRs we get a week, yes, there are often and always reports that would lead to suspicions of IMVE, but I think there's a distinction between somebody who may be supportive of ideologically motivated violent extremism and the event itself. So it wasn't that the event was funded in view of supporting IMVE activities. There may have been individuals who may have been involved who have those types of leanings, and we would have received STRs on them regardless of whether or not the emergency measures orders would have been in place. And we don't, as I mentioned earlier, see all transactions. The reporting that we receive in STRs are reports that the institutions suspect would be relevant to a money laundering or terrorist financing investigation. And once we get those reports, we do not simply disclose all those STRs because we still have to meet our own threshold, which is different because we have a different threshold as professional intelligence analysts. Once we meet our threshold to suspect that it would be relevant to a money laundering or terrorist financing investigation, that is when we would put together the financial intelligence to disclose it. So we do not see all individual transactions.
Okay, for the purpose of the record, could you give me the term STR in its form, in its full form?
I'm very sorry. It's a suspicious transaction report.
Thank you.
It's
important for the record. Thank you.
I'm sorry about that.
Could you take a moment to explain your threshold from an intelligence perspective, because it's different than an investigative threshold?
Thank you for the question, Mr. Chair. Our threshold is a level of suspicion. So if we suspect, so it's reasonable grounds to suspect, it is much lower than investigation, much lower than court, because what we provide to law enforcement or national security or CBSA or internationally is intelligence only. It is not evidence. It is intelligence, and it's based on our reasonable grounds to suspect that it would be relevant to a money laundering or terrorist financing investigation or threats to the security of Canada.
Okay, thank you. And my understanding that this is for both finance and FinTrack. It's my understanding that work on amendments is underway in the Department in Finance to close the crowdfunding gap. Is there an anticipated timeline, and what is the particulars that you're hoping to get to?
Yes, that is accurate. Actually, the gap has been, the measures are now permanent. Regulations are in place as of the 27th of April.
Go ahead.
No, that's it.
Okay, so can you tell me what are the advantages? What are you attempting to close?
So what was closed is, well, I can turn to Julien, but to give more details after, but we added to the list crowdfunding platforms as well as payment service providers that were not covered previously. So I'll turn to Julien to better explain.
Sure. So briefly, essentially what the new regulations did is they made permanent what was contained in the emergency measures in terms of the obligations on crowdfunding platforms and payment service providers to register and to disclose suspicious transaction, and also put on them sort of heightened responsibilities in terms of due diligence and verification of clients.
And very quickly, can you tell me whether or not you've had any discussions or anyone within your departments with respect to, on an international basis, to look at other countries and how they may have dealt with this issue similarly?
We have looked in terms of benchmarking what other countries are doing. Canada is one of the first in terms of the coverage of crowdfunding platforms. However, in regards to payment service providers, the European Union, as well as Australia, already cover those entities for purposes of anti-money laundering and anti-terrorist financing.
Okay, thank you very much.
Thank you. We will now move on to Senator Carignan. Monsieur Carignan, the floor is yours.
Thank you. My question is for Ms. Jacques. Ms. Jacques, you said earlier that there were no consequences for financial institutions for not freezing transactions with designated persons. Is that correct? Yes, that is correct. So can you explain to me, in 7, it says no proceedings under the Emergencies Act and no civil proceedings lie against an entity for complying with this order. So there's immunity for those who comply, and those who don't comply, they couldn't be subject to anything? Yes, it's a clause that provides immunity, as you see in Section 7, to entities that complied in good faith with this order. So if there's no immunity and you didn't comply, then can you be sued? Because in Section 10 of the order, there's a penalty of $5,000, 10-2, by a maximum of $5,000 with a maximum 5-year imprisonment for those who don't comply. Yes, with the Emergency Measures Act. You're talking about the regulation? Yes. I didn't think that applied to the order. Okay. But you can ask the question to the Department of Justice. Okay. So regarding seizure, you say it's not a warrant. I just want to remind you that it comes from the order, not from a judge. So it's an order to block. And you could look at the Laroche case in 2002 at the Supreme Court that said a blocking order is a seizure under Section 8 of the Charter. There's no blockage order by the court. So when it comes from the Governor and Council, the warrant is not a warrant. Well, it says to cease dealings, cease providing services to designated persons. So I don't think we agree, perhaps, on the concept. I see it as a preservation measure, as a freezing. I could give you an example. If a bank sees a transaction they think is fraud, they may decide to freeze the account to ensure that the bank account isn't accessible. So would that be a seizure? So in 2, why stop any dealing regarding a property? It could be a house, a vehicle, a building, a company. What is the advantage of having an order where a bank is told, stop all financial dealings, stop providing financial tools to Mr. Tremblay, for example, who's on Wellington Street in an illegal protest? What is the advantage of doing that? Well, the first advantage is to ensure that people stop funding illegal activities. The second is to deter people to say, look, if you leave Parliament Hill, your account will be unfrozen. So it was to encourage people to leave. So that was the goal. Illegal protests have a financial impact. Have you seen offenses where banks are used to encourage people not to commit a crime? For example, somebody who robs a bank, you tell the bankers, look, you've already done this, so to prevent you from doing it again, instead of going to court, we'll seize all of your financial activities. Well, it was the Emergency Measures Act. It was an extraordinary situation. It's the first time that the Emergencies Act was used. So, of course, it's not a usual situation. Thank you.
Stephanie?
Oui.
Okay.
Done? Yes.
We will now move on to Senator Harder. Senator Harder, you have 5 minutes and the floor is yours.
Thank you, Chair. Madam Jacques and Mr. McCallop, I'd like to pursue the issue of non-Canadian source funding and the way in which you became both aware of that and what actions you took, if any, to try to bring in line that source of funding to the effort to to stop the funding of illegal occupation in Canada. For example, did you have discussions with your American counterparts? Do you see this as a gap in the existing framework that you put in place? And how would you, going forward, ensure that Canadian actions, which are foreign sourced, would not be a loophole in funding of illegal activity? Madame Jacques first, please.
Well, thank you. If you do not mind, I will turn the question to Julien Brazeau.
Sure. So in terms of sort of the international reach, we became aware through media reports in terms of the fact that potential U.S. funds were being used. In regards to sort of the measures that were put in place for crowdfunding platforms and PSPs, they apply equally to firms that are domiciled outside the country. That being said, obviously, from an enforcement perspective, our ability to enforce against them is limited. I can say there were no conversations at the time with our U.S. counterparts in terms of, at least of my knowledge, in terms of a potential gap, and you know. Leave it to maybe my colleagues at FinTrack to speak more specifically to sort of enforcement challenges that they may see across the border. But essentially, the measures were meant to capture both domestic and international firms.
Before we go to FinTrack, I wonder if I could follow up. I don't know how much nuance to read in your comment at the time. Have you had conversations with American authorities since?
No, I'm sorry. I shouldn't have given any sense of nuance.
No, I just, I know how to use words.
Absolutely. Yes. No, I haven't had any discussions with U.S. counterparts since.
Mr. McCullough, could you brief us in respect of the FinTrack relationships?
Relationships with whom?
U.S. counterparts, if any?
We have a very good relationship and an ongoing relationship with FinCEN, which is the FIU counterpart, FinTrack's counterpart in the U.S. They were well aware of what was going on in Canada. They also received suspicious activity reports from their entities, but I don't believe the crowdfunding platforms report to FinCEN. So it was more along discussions and what might happen going forward on covering crowdfunding platforms and the challenges that we would have. I know that on our compliance side, we do have an international supervisory forum where information among the Five Eyes is shared in terms of challenges and successes with respect to compliance across the Five Eyes, which are the 5 countries. For those that don't know, I'm sure you're all well familiar with the Five Eyes. So that is, those discussions are ongoing and they take place on a regular basis.
If I could pursue this a little further, you say you're having those discussions now. Do you expect that that will lead to some institutional relationships to fill this gap, or to otherwise be assured to each other that you will not become victims of offshore funding of illegal activities?
I'm not sure. I would turn to Ms. Achimov with respect to the compliance side. I don't think they're, the opportunity to provide money from outside of Canada into Canada will always exist, and these platforms are international. But I believe that having the crowdfunding platforms now as reporting entities to FinTrack and the due diligence required will enhance their ability to ensure that their platforms are not used for nefarious purposes. But they are used by many people to raise funds for very good causes, and that money that they raise could in fact come from outside of Canada and would not be in any way looked upon badly.
Thank you. I appreciate the assurances that you're providing.
Thank you very much, and we will conclude this round with Senator White, at which time we will take a 5 to 8 minute break to allow people to just take a breather and then come back and resume. So, Senator White, the floor is yours for 5 minutes.
Thank you very much, Mr. Chair. Thanks again to the witnesses. If I may, Assistant Deputy Minister Jacques, just so we're clear, the list of people, organizations were provided to financial institutions. Financial institutions then send information back in meta format, so no specifics. Do you know if the RCMP received information beyond metadata specific to the account holders, the amounts in each account, where the money was derived, et cetera?
I do not know if they did.
Have they ever discussed with you the fact that they had that information about specific account holders?
No.
Do you know how, can you give me specifics on how long the accounts were inaccessible for the account holders?
Well, certainly they were inaccessible for as long as they were involved in illegal activities. I know that they started unfreezing some of those accounts on the 21st, and they were completely unfrozen by the 24th.
Do you know if all criminal investigations were completed by the time they were unfrozen?
I'm not aware of any criminal investigations. That's not information that I've received at finance.
So for about a week and a half, this large amount of money and 180 give or take accounts were frozen. Not sure if any criminal investigations were conducted, and none of the accounts were continued to be frozen past that period. Is that correct?
That is accurate. Okay. I think it was approximately 280 accounts.
Okay, thank you for that. Mr. McKillop, were any of the, and I'll call them targets only because I'm sure that's what the police would have referred to them, any of the targets found on the list, were any of them provided to FinTrack to identify whether or not you had further information that could be provided to the banks or financial institutions?
Thank you for the question. No, in fact, we cannot go back to financial institutions and provide them information on specific targets.
No, I understand you couldn't.
So.
No, sorry, Mr. McKillop. I understand you couldn't go to those banks, but did any law enforcement agencies go to FinTrack and ask FinTrack to get information or provide information that they could then provide to financial institutions?
No, Mr. Chair. If law enforcement RCMP were to come to us, it would be in the context of their own investigation if there were investigations ongoing, not for the purposes, and it would only be for, again, for the money laundering or terrorist financing, which means that we could not just give them information so they could go to the bank. That would be outside of our mandate. You asked, the member asked whether or not there are, I believe there were media articles about in Ottawa saying that there were ongoing investigations. And if those ongoing investigations have a money laundering component, then I'm sure the RCMP or Ottawa Police or any other police force would come to FinTrack to seek our financial intelligence at that point. But I don't know about the ongoing investigations.
So you're saying that has not occurred? They have not come back and asked you for information specific to any of the entities?
To any of the individuals, are you referring?
Yes.
Sir?
Yep.
Some of them would have come back with voluntary information records where they seek information intelligence from FinTrack on individuals they're investigating. The reason for the investigation may vary, but there would have to be a component of at least the suspicion that anything I disclose would be relevant to a money laundering investigation. But again, I do not know of the 280 or the list that was given to any of the banks, so that link is not necessarily there.
Thank you very much, Mr. Chair. That's it.
I will now suspend the meeting for
bathroom break.
5 minutes. Thank you. members, I think you've heard the. Mr. Brock, if you could repeat.
Just trying to ensure fairness for the final round. Final round would start at 9 o'clock. If we went 5 minutes, there'd be some committee members who would not be afforded an opportunity of asking a final question. So that being said, my proposal is to drop the final round to 4 minutes per person.
We do have till 9:30. And I would also note that the time allocations originally were by parties and Senate. You always do have the opportunity to split time, but I think we're gonna end up being okay. And you know, we've had some of the members concede some of their final seconds, and if we get to the end where we have to do what I will affectionately call the 410 fire round of 1 minute questions or 2 minute questions, then we could do that at the end. Does that make sense?
Yeah.
Mr. Chair, to Mr. Brock's point, I would like an opportunity to ask another a final question. So would there be 2 rounds left in from now until 9:30? Would that be?
Well, the more we talk about it, the less likelihood there is. We're going to push for it, and if there's some will at the end to have some leeway to ask some final questions in a round, then we're certainly open to that. Does that make sense? Or do you want to? I mean, look, I'm at your discretion.
I think we go back to the original time allocation at this point, which was slightly different. That is, of course, very helpful. So
very helpful indeed. And I shall say that they were fine questions indeed, Senator Harder. Well, I did mention Senator Harder. I'm sorry? Yes, we're going to continue. And with that, we will go back to the top of the round, which is the Conservative Party. And Mr. Motz, you have the floor for 5 minutes.
Thank you very much, Chair, and thank you, witnesses, for hanging in with us. Ms. Jacques, you had a chance to recoup. I'd like to ask you some more questions, if I may, please. In the first round, you indicated to some of the questions I asked that you couldn't answer given lawyer-client privilege. And I would take it to mean that you were getting advice and you were considered the client. Would that be accurate?
Yes.
So with your background, you know that in Canadian law, the client can waive lawyer-client privilege. So are you willing to waive that privilege?
No, I'm not, and I'm not in a position to do so. It would have to be an appropriate person. I think that would have to come from the clerk, I believe.
Okay, thank you for that perspective. So Senator Harder and others asked, and Senator Bonifants asked some questions about the sequencing and when you knew and what you did about it, and that's been helpful, I guess, to give some perspective on the timing. But 2 times so far, Ms. Jacques, in your testimony today, you were giving specifics about what your goals were. And you said that you had basically 2 goals for the account freezing. One was to stop funding of what became an illegal blockade or illegal protest after the Emergencies Act was enacted. And then 2 was to dissuade people from donating. I find your use of dissuade to be an interesting choice of words. It could mean to intimidate, to ensure that people didn't continue to fund. And you know, at any time, was your intention to intimidate Canadians from donating?
No, absolutely not. And it was dissuading people from staying on the Hill. So certainly the intent was to ensure that there would be no funding of illegal activities, and certainly to ensure that people would go back home and stop the illegal activities that were ongoing on the Hill.
Okay.
Yes.
And the illegal also became donations. That was also considered. So in retrospect,
blockades.
Would the intimidation that Canadians felt be considered an intended action, or was that an oversight? Because Canadians did feel intimidated by the Emergencies Act and some of the economic measures order.
It's hard for me to speak as to how Canadians felt. I know there are a lot of Canadians that felt relief that measures were put in place to help the
Well, I
situation.
can tell you
which
that
was
many
untenable.
Canadians have lost trust in government, and I can tell you that many Canadians lost trust in the financial institutions. I can tell you directly that during the invocation of the Emergencies Act, a number of banks in my riding had to close their doors on some days because of the run on the banks. That they had to shut their doors and wouldn't let anybody else in because everybody was trying to close their account. I met with the advanced life underwriters yesterday. A group of them had a reception here, and I talked to a number of them who said that we would be shocked at the tens of millions of dollars that have left the banking system and have gone to them because people no longer trust the banks, and the banks are left to wear, the actions of the government here, and I find it rather disappointing, rather disturbing actually that that's that's what's happened. So, were you at all aware or even attuned to the fact that the actions of the Emergencies Act had these unintended consequences? I
was made aware in one circumstance that there was temporary, these people took their money out because they were concerned that because they gave $10 or $20, their bank account would be frozen.
Okay. Well, I will tell you that yesterday my office received a phone call
Mr. Chair, could perhaps the witness be allowed to answer the question? This is the second time Mr. Motz has interrupted her.
It's my time, and I'd like to ask the last question. I have
his
limited time.
And he can redirect his
Ms. Jacques, I will tell you that today or yesterday, my office received a phone call from an elderly gentleman who we had helped deal with some pension issues, and him and his wife have closed their bank accounts, and we managed to make it very, very clear to me. They have closed their bank accounts, and they're pulling every investment dollar they have in a chartered bank because they do not trust this government, and they do not trust the banking institutions any longer. That's the unintended consequences of the actions of this government.
We'll take that to be a concluding comment and not necessarily a question. We will go on to Mr. Nakvi, who has 5 minutes. Mr. Nakvi, the floor is yours.
Thank you very much, Mr. Chair. And I can tell you what I think Canadians were feeling intimidated by was the illegal activities that were taking place by way of the occupation in Ottawa and the blockades that were happening around the country. I'm going to direct my question both to Ms. Jacques and Mr. McKillop, and I just want to clarify a few things so that I can understand, and I'm sure as Canadians want to understand as to what we're talking about. Is it my clear understanding that the orders and the regulations under the Emergencies Act that we're discussing right now did not give Department of Finance or the Government of Canada any power to freeze any bank accounts?
That is accurate.
Mr. McKillop, same question to you, that the order or regulations that we're discussing right now did not give FINTRAC give any powers to freeze any bank accounts?
That is correct, Mr. Chair.
Okay. Let me also ask you that it also did not give any power to either of these organizations to direct banks to freeze certain bank accounts?
That is also accurate.
Mr. McKillop?
That is also accurate.
Am I also hearing correctly from both of you that you were not directing the RCMP or any police investigation in terms of any individuals or entities that may be involved in the illegal activities?
That is also true. We were not involved at all.
Mr. McKillop?
That is also correct.
And so the conversations that were taking place in terms of investigations and enforcement were solely between the RCMP and the financial institutions?
To the best of my knowledge, yes. We were not involved.
To the best of my knowledge as well, I think the RCMP would be able to respond more directly in terms of the content of the discussions they had with the banks, but it was not involving FINTRAC.
And Ms. Jacques, as I have heard from you during the testimony, that the purpose behind the orders and the regulations we're dealing with was to put an end to the illegal activities that were taking place.
That is correct. There was a hope that it would help achieve that purpose.
In your view, did it help?
I believe it did, based on some comments I received from the RCMP, but I believe that I'm sure they would be able to answer that directly.
Mr. McKillop, can you comment on that particular aspect from your perspective?
Not particularly, Mr. Chair, from my perspective. The transactions, because the accounts were frozen and the fundraising was essentially frozen at that point and ceased, the transactions, we would not have seen any transactions. We don't monitor transactions anyway. Whether or not it had the effect, it would appear, again, as Madame Jacques mentioned, the RCMP would be best placed, or the Ottawa Police would be best placed to inform the committee on whether or not the possibility of having your account frozen if you stayed on the Hill was in fact a significant motivation for people to leave when they finally left peacefully.
Okay, great, thank you. I also want to ask the application of the order and the regulations, that it was prospective in nature when it came into force, not there was no application retroactively. Is that a correct understanding, Ms. Jacques?
That is also correct. The order was solely prospective. It was not retroactive in application.
Mr. McKillop, is that your understanding as well?
That is correct, sir.
Okay, and Ms. Jacques, it is your testimony that all the accounts or the financial products that were frozen have been unfrozen as of February 25th, as I understand?
The 24th, that's right.
24th. And why is February 24th significant?
Because we received a final report saying that all accounts were unfrozen.
Okay, thank you. And I know there was a bit of a discussion. I see the red-orange card that's up. Can you quickly outline the privacy aspect that has been maintained in order to protect the privacy of individuals or entities involved?
Yes, as you will have seen from my testimony, we received no specific information. There were dispositions in the order that allowed sharing of information between law enforcement and financial institutions, but not otherwise. So we have not been privy to any specific information, just aggregate amounts as I've reported.
Thank you very much.
Thank you. We will now move on to Monsieur Fortin. Monsieur Fortin, pour 5 minutes.
Mr. Fortin, 5 minutes. Thank you, Mr. Chair. My questions will be for Mr. McKillop. Mr. McKillop, I heard in your testimony earlier, you said that you usually receive about 9,000 STRs, suspicious transaction reports. You receive about 9,000 per week regularly. And during the 8 days of the order, it was the same thing. Did I understand that correctly, or am I mistaken? Thank you for the question. Yes, you've understood that correctly. It was regular during that week. We received about 9,000. Those reports come from financial institutions, is that correct? Yes, among others. We have a number of sectors that report to us. When you receive those reports, there's verifications that are done to determine whether they really are suspicious transactions. I imagine it wouldn't be all of those reports that are grave, serious, or are they all serious? Thank you for the question. They are all suspicious transaction reports. So the reporting entity suspects that it's a transaction that would be related to money laundering or terrorist financing. But then for us to disclose to the police, we have to meet our threshold, and we have another reasonable doubt threshold to verify whether we really think it's related to money laundering or terrorist activity financing. So if I've understood correctly, 9,000 transactions per week, there are people in your office who verify them one by one. People and technology. It's difficult to do it just with human eyes, but we have technology that assists us, and we look for keywords, and then we go from there. And we have 300 million transactions in our data bank, so before we make a disclosure, based on a suspicious transaction report, we look in our data bank to see if there are other transactions that could support the doubt, broaden a network, identify other people who are involved in a strategy, for example, or a plot before preparing a disclosure that we would share with police or national security bodies or internationally as well. Inaudible. An approximate percentage of those transactions that after having done your verifications, you consider to truly be suspicious. Exactly. How many? Oh, I'm asking you the percentage. Is it half of the 9,000 that you deem to truly be suspect? 80%, 20%? Can you give us an idea? It's very difficult to say. But this year, over 2,000 disclosures have been made to the police on a total of how many? Well, those are disclosures, and in each disclosure, there could be one STR, or there could be 1,000, 2,000 reports put together. But you say about 9,000 per week. I'm sorry, I don't want to interrupt you, but time goes by quickly. So about 9,000 per week. I haven't done the calculation over 52 weeks, but that's a significant number. So you have 2,000 that you've retained. No, it's not correct. The 2,000, those are the disclosures we've made to police, for example, the RCMP. Not just the RCMP, of course, it's all police forces throughout Canada. But each disclosure can contain thousands of reports. Okay, I just have a few seconds left. If I take the week, those 8 weeks, the order, were there more or about the same as usual? About the same as usual. Thank you. Thank you, Mr. McKillop.
Thank you. I will now pass the chair over to Senator Boniface for my 5-minute round.
Mr. Green, you have 5 minutes. You please proceed.
Thank you very much. Through you, Madam Chair, to Ms. Jacques. Ms. Jacques, you've heard in my earlier lines of questioning, I feel a little bit dismayed about what I would consider to be the lack of seriousness around the preparation, briefing, and direction of both FinTrack and the department. You provided in your testimony that you were made aware 2 days prior of the Emergency Act. Was there any activity that would have happened in your department anticipating, recognizing that this might have been a possibility, that would have been preparing policy briefings for senior management and the minister?
Well, there's no doubt that looking at the events unfolding, being the Assistant Deputy Minister responsible for the financial policy sector, that we looked at those events and certainly start thinking as to what could be done if needed to be done. But I found out that the Emergency Act would be invoked solely that weekend. I think the Saturday, I believe, was the 12th.
So in the lead up, and when you're
So we
doing
had
this,
very little time.
yes, I appreciate that. And I would suggest to both, while at times it might feel hostile, I feel like the pressure on this particular committee will be to provide recommendations to the House and to the Senate and to government, essentially, to hopefully provide clear parameters for all involved should this ever happen again, clear definitions, clear roles and responsibilities. And I feel like in the course of this particular meeting, some of the responsibilities have been a little bit confusing at times. And so I'll ask you, in your lead up, in this policy briefing and analysis that you're doing, recognizing the state of the country, how did your department assess the threat level posed by the financing of the occupation and the blockades leading up to the emergency declaration, so prior to its consideration?
Yes, certainly, I didn't do a threat assessment per se, but we were concerned to see that there was so much money that was being funded through the GoFundMe fund, I believe it's called. And when we saw that they decide to freeze all activities and actually remit all monies to donors, certainly it caused us some concerns that they were worried that the funds were being used for a purpose that they were not comfortable with. So certainly,
was your department involved in any of the economic impact assessments that would have been provided in briefings to either public safety or cabinet or the PMO's office?
I was not involved in any of those. I cannot answer that question.
So nothing around the national economic or financial losses, there would have been nothing coming from your department on that?
I did not receive at that time certainly any numbers concerning that.
So given your position, your fairly senior position within the department,
Yes.
how would those assessments be made and by whom?
With respect to the economic impact,
Correct.
well, I'm sure that, I don't know exactly in the group who would have made those assessments, if any. I'm not aware. I don't have the answer to that question. I don't know, Julien.
Well,
if you can
I would
help.
state to you, through you, Madam Chair, that much of the invocation in its reading on the face value of it highlights the economic impacts on the country as a part of the threat to national security. And I find it interesting that your department wouldn't have had any type of policy analysis or submissions on that. So I'll go to my next question, which is, did your department, in its consideration of the state that the country was in the lead up to the invocation, have any tools prior to the invocation of the Emergencies Act that would have prevented the financing of the occupation of Ottawa and the border blockades?
We did not have any tools that would allow us to freeze those accounts, no.
Mr. If I
just,
could,
if I
thank you.
may-
I appreciate that. I'm going to take my time back. Mr. McCullough, if I could, to you, through you, Madam Chair, did FinTrack have any tools for interventions that might have been effective prior to the invocation of the Emergencies Act?
Madam Chair, we would not have had any tools to stop funding of anything. We cannot freeze accounts. We cannot stop funding. We cannot direct financial institutions
Yes, that's
or
correct.
crowdfunding platforms.
I did hear that in your earlier testimony. Thank you. Okay.
Mr. Green, your time's up.
Thank you very much, Madam Chair. And I will, in taking back the chair, continue on with yourself, Senator Boniface. You have 5 minutes. The floor is now yours.
I'd like to direct the question back to Madame Jacques. I wonder if you'd just like to finish your answer to Mr. Green so we get the benefit of the full answer.
Yes, thank you. I'm not saying that I did not say that there was no information on the economic impact of the events that were ongoing, only that I was not privy to those discussions. And I wanted to maybe ask Julien Brazeau if he can complete my response or add to it.
Mr. Brazeau, you're on mute, I believe.
Apologies. I was just saying, from a financial sector policy perspective, we weren't part of any discussions on the broader economic impacts of what was happening at the border. But I would be speculating, but I would expect that discussions were taking place within the department in terms of getting a sense of what the economic impacts were.
So if I'm clear then, from both your answers, your view or your sense is that there's something within the Department of Finance but doesn't fall within your particular area. Is that correct?
That is correct.
Okay, thank you. And I'd just like to go back to the questions around amendments that are underway. We spoke about that in my last line of questioning. And I'm wondering whether or not there is anything that is duplicate of any provincial legislation that requires registration and reporting. I'm just trying to figure out how the provincial legislation, if it exists, it would interact with the federal legislation around registration and reporting.
To my knowledge, there's no duplication, but again, maybe Julien Brazeau may want to add.
Yeah, no, the reporting requirements are specific to, again, the proceeds of crime, money laundering, and terrorist financing, which is a federal remit, a federal regime. So the registration requirement is with FinTrack for purposes of the PCML TFA. So there is no overlap between any other registration requirements that may exist provincially.
Okay, and again, Madame Jacques, going back to sort of the international, Mr. Brazeau, you may want to speak on that. I'd like to have a little more information on what where you look at other jurisdictions, so European Union, Australia you mentioned. Can you just give us a little more detail around that? And I'm particularly interested in New Zealand, given what they were dealing with almost concurrent with us.
So I can't speak specifically necessary to sort of what countries we're facing at the time, but I can say sort of Canada is part of what we call the Financial Action Task Force, which is sort of the body which sets sort of standards around anti-money laundering and anti-terrorist financing. That body has identified in the past crowdfunding platforms and payment service providers as representing certain levels of risk. And as I said, some jurisdictions have already sort of moved to ensure that payment service providers are subject to the types of disclosures and registration that our PSPs are now subject to. In regards to crowdfunding platforms, we are the first jurisdiction that I know of that have put in place these provisions.
So when you refer to the task force, I'm assuming that is, a Five Eyes or something, a larger number of countries involved in that. Have they done any reports on crowdfunding particular that would be helpful to this committee or that are public?
I'll have to take a look and circle back just to confirm whether they have a report that we can share.
Okay, that would be helpful. And can you tell me whether or not there are or is intended to be any ongoing conversation with their American colleagues in terms of issues around crowdfunding and how that may work coming into the future, given the experience that you've had through this declaration of emergency?
I might ask my colleagues at FinTrack to speak directly to that, given that they oversee sort of compliance on a going forward basis.
Thank you.
So, Mr. Chair, maybe I'll take that question. We have an international supervisory forum where we share leading practices and experiences. It's still early days, so we will certainly continue to have dialogue to understand how other jurisdictions are making this work. As my colleague, Mr. Brazeau, said, we are the first who are looking at crowdfunding. And so we are the ones who are experiencing some of this, and we will be sharing leading practices from a supervisory perspective. It's early days. The regulations came into force through the Canada Gazette on April 27th. We're in the process of registering, providing information, doing outreach. So it's still very early days in the process, but our conversations are based on sharing leading practices.
Thank you. Thank you.
Thank you.
Thank you, Senator Boniface. We now have Mr. Brock for 5 minutes. Mr. Brock, sorry, my apologies. Je m'excuse. Je m'excuse.
I'm sorry. My apologies. Senator Carignan. Thank you. My question is for Ms. Jacques. I see the obligation regarded to freezing, and I'm trying to find a property or service that wouldn't be included. So people's mortgages would be affected, their life insurance, their RSP, their TFSA, their children's RESP. The only thing that's not included is the vehicle insurance for a vehicle that's not participating in the illegal gathering. But the house insurance is covered, is included. The business's insurance, is that correct? It's very broad, including vehicle insurance. Okay. What inspired the creation of this? It's pretty imaginative to say that there could be no dealings with an individual on all economic aspects of their life to deter them from committing an act. Where does that source of law come from? Was it China or Russia that was the inspiration? We didn't draw inspiration from any country. The situation that we were experiencing was exceptional. The government decided to invoke the Emergencies Act, something that had never been done before. And so these are measures that were targeted, time-limited, for a specific reason. So you thought it wasn't enough to have the criminal sanctions that the people could be subject to. I have a list. I asked for a list of the offenses committed. There was mischief. There were charges, offenses. So a maximum of 10 years in prison. Counseling others to commit an offense is a maximum of 2 years in prison. Obstructing the work of a police officer is a maximum of 2 years. Driving when not allowed, a maximum of 10 years. Making threats, maximum of 5 years in prison. Weapons, up to 10 years in prison. Dangerous driving of a motor vehicle, up to 10 years in prison. So to you, it wasn't enough. That wasn't enough deterrence. There had to be the seizure, the freezing of all of the economic activity of an individual to encourage the individual to leave Wellington Street. Listen, the government wanted to take measures to ensure it was an emergency situation, so there are a number of measures that were put in place to try to resolve the situation, and we saw that the situation was resolved very quickly. So I think there was a positive impact. No further questions.
Thank you very much. Committee members, I'd like to note that we are now with 10 minutes left officially for this next round. There's also the consideration of what is are we done at 9? Oh, 9:30, my bad. My bad. Maybe that was wishful thinking on my behalf. In my mind. Okay, so with that being said, we'll go back to the top and we will have Mr. Brock for 5 minutes.
Thank you, Mr. Chair. To Madame Jacques, 3 days after the Emergencies Act was issued, February the 17th, the Coastal GasLink Northern BC worksite came under attack. Heavy machinery smashed beyond repair, bulldozers smashed, security trucks pockmarked with holes made by axes, people in disguises attacking workers, leaving them severely assaulted and injured, millions and millions of dollars in damage. To what extent were those responsible? To what extent were those responsible for funding that illegal activity, directly or indirectly? Did they have their accounts seized?
Unfortunately, I'm not able to answer that question. I do not have that information.
You accept the fact that this particular order was applicable all through Canada, correct?
It was applicable throughout Canada, yes.
Right. So
but I do not
can you undertake to the committee to make inquiries as to what steps the government took to address those illegal activities in BC under the auspices of the Emergencies Act?
If you could please state the point of order.
On relevance, I believe we agreed as a committee on the scope of our study and that this falls beyond the scope.
Yeah. Thank you for noting that. Please continue with your questioning.
Thank you. So, Ms. Jacques, will you undertake to provide information to this committee from any source as to why the government did not instruct any financial institution to take steps to freeze the accounts of those who were involved in that illegal activity?
I'm unable to undertake to provide that information. The government did not specifically direct anybody to, or any financial institutions to freeze account. I do not have that information and would not be able to provide it.
I'm not sure if there was a ruling on my point of order.
Yes, I've allowed him to continue the questioning.
Sorry. Thank you,
That was
Mr.
the
Chair.
ruling. I will note that your other microphone's on. And Mr. Brock, you may continue.
Thank you. So you could not obtain that information? Is that what I'm hearing?
I would not be able to obtain that information.
Okay. would you agree with this particular statement that weaponizing the financial system to resolve domestic dissent or even criminal justice issues is a terrible precedent to set? Do you agree or disagree with that?
As a witness to this committee, I do not believe it would be my role to answer such a question.
The government has stated several times that they needed the Emergencies Act to shut off funding to organizations which were undertaking illegal activity in Canada. The issue we've discussed quite a bit already is that the Emergencies Act can only be invoked if there is a national security emergency that cannot be effectively dealt with under any other law in Canada. Much has been said about how the GoFundMe was canceled before the Emergencies Act was invoked. Can you say definitely that there were no other laws that could have been used to achieve the government's goal of depriving or choking off, as Minister Freeland often refers to, choking off the funding of the convoy from those sources of funds?
I was not involved in any discussions leading to the decision to be made to trigger the Emergencies Act, and as such, I cannot comment.
The Minister of Justice, the Attorney General of Canada, appeared on national television and was asked who the economic measures, in other words, freezing assets, would apply to. He was quoted, "If you are part of a pro-Trump organization, you ought to be worried." This seems to go beyond the stated intentions and comes awfully close to the government signaling it was willing to target political opponents. Can you clarify whether Minister Lametti went too far in his remarks and what sort of scope the financial measures of the February 14th order in Council had in terms of who should have been captured by those asset freezes?
I'm sure you will understand that I'm not in a position to comment on this statement.
Of the 280 accounts that were identified and accounts frozen, how many particular individuals are we talking about?
Briefly, with the answer, please.
I think this is an answer that the RCNP would be able to provide you.
Thank you. That does conclude the round.
Thank you.
We will now go to, I believe, Ms. Bendayan
Oui,
for
merci.
5 minutes.
Merci, beaucoup.
Yes, thank you very much, Mr. Chair. Ms. Jacques, there seems to still be confusion among certain committee members regarding the terms seizure and freezing. I'd like to ask you to provide in writing the definitions of those terms so that we can all be on the same wavelength.
Madame Jacques?
On peut vous donner une...
We can provide a definition and certainly repeat what is in Article 2.
I would like to similarly ask if you can table with this committee the definitions, your working definitions at FinTrack of money laundering and terrorism activity.
Absolutely, Mr. Chair. It's, would you like that tabled with the committee? I'm sorry, or would you?
Yes,
like
I would like that tabled in
now?
writing with the committee, please. There seems to be some members who do not understand those terms. I would also like to ask any witness who would be comfortable answering if any financial measure was applied retroactively. In other words, were any banks engaged in the seizure or freezing or any other action during the protest prior to the invocation of the Emergencies Act, to your knowledge?
No, nothing was done retroactively, certainly not based on the order under the Emergencies Act.
Thank you. I'd like to cede the remaining time to my colleague, Mr. Varani.
Thank you. Madam Jacques, in the Economic Measures Order in Part 3, Sub K, it talks about virtual currency. Is that a reflection or a reference to things like cryptocurrency?
Yes, it is.
And did prior to the advent of the Emergencies Act invocation and this order that I'm looking at, did we have any? Did the government have any tools for regulating the flow of cryptocurrency for illegal activities in this country?
Not per se, but there were dispositions with respect to the FINTRAC ability to report on those. I can maybe ask either Mr. McKillop or Donna Shimoff to complete the answer.
Yes, Mr. Chair, we do have the ability as of last year to regulate virtual currency.
What additional tools did this Emergencies Act portion of Section 3K and 3L give you in terms of addressing the illegal blockades and the funding of them via cryptocurrency? What was added via this invocation?
What was added was, Mr. Chair, was the fact that we now had, we had crowdfunding and payment service providers added as reporting entities.
Okay, and that was through the invocation of the EA. And can you give us a sense of the scale of cryptocurrency funding at the time of the invocation and your concern about this problem going forward? So the time of the blockades around the country, what was your sense of concern about cryptocurrency funding?
Mr. Chair, I don't believe that we had necessarily a sense of cryptocurrency per se. There was concerns about crowdfunding and payment service providers, and those were addressed as part of the Emergencies Act.
Was that concern accelerated when GoFundMe froze and started to return donations, but another entity called Give, Send, Go, based out of the United States, was accumulating funds and directing them towards illegal blockades in this country?
Mr. Chair, I'm not in the position to comment on that. I'm not aware of that. Solely the whole issue surrounding the fact that there was a gap with payment service providers and crowdfunding, and that was addressed as part of the Act.
And now the regulation that's since been enacted after the invocation of declaration has ceased regulates that situation on the go-forward basis. That's correct?
Mr. Chair, yes, that's correct. And the Canada Gazette on April 27th added those business offerings of crowdfunding platforms and payment service providers as part of reporting entities, as well as businesses located in foreign jurisdictions that meet those criteria as set out in the Act. They too have an obligation to register with FINTRAC as foreign money services businesses, and that was the case since June of 2020.
Thank you.
We will now move on to Monsieur Fortin pour 5 minutes.
Mr. Fortin for 5 minutes. Thank you, Mr. Chair. My questions will be for Ms. Jacques. Ms. Jacques, earlier, in response to the questions asked by my colleague Mr. Motz was suggesting 2 reasons you gave to justify the declaration of emergency. And perhaps I didn't note this correctly, and I was translating from memory, but you said to deter people from giving money to organizations that wanted to break the law. And the second point was to prevent money from going towards breaking the law. Did I understand those 2 motivations correctly, Ms. Jacques? I'm sorry, my internet cut out there. I don't know, Julien, if you've understood the question. Mr. Chair, could you put it back to 0 for the time so I can ask again? Yes, go ahead, please. I'm sorry.
You'd ask again. Yes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. So, Ms. Jacques, I was saying earlier, in response to Mr. Motz's questions, you gave 2 reasons to justify the declaration of emergency. One was to deter people from giving money to organizations that wanted to break the law, and the second was so that the money wouldn't go towards breaking the law. Perhaps I didn't note that correctly because you answered in English. The question was in English, so I translated it from memory in my notes. But correct me if I am incorrect. Are those the 2 reasons you gave to Mr. Motz? I don't think it was a reason to invoke the Emergencies Act and the order. They were 2 reasons that helped deter people from continuing to provide money for illegal ends and to continue to participate in illegal blockades. But But to justify the order, is that correct? Not to justify the order, no. Once the decision had been made, we weren't involved in making the decision. I'm sorry, I don't want to interrupt you, but I understand. Had I noted that correctly, that those were the two reasons for you? It seems it's not the case. Okay. What I mean is it's the reason why those measures was put in place, not why the Emergencies Act was invoked. So the measures we find in the order. The other question I had is that for the same question from my colleague, Senator Carignan, a similar question, you mentioned that seizures were done to encourage people to leave Parliament Hill. Have I noted your answer correctly? Well, what happened is that if people had given funds and were participating in illegal activities, and those people decided to stop participating in legal activity, then financial institutions, that's the effect. Excuse me, Ms. Jacques. That's the effect you're talking about. The reason that justifies imposing these conditions in the order, from your answer to Senator Carignan, it was to encourage people to leave Parliament Hill. So that's why their bank accounts were seized or frozen. I think that was certainly a secondary effect. Okay. You said it was the reason earlier. Do you no longer agree with your previous answer? What I mean is that we put those measures in place. The goal, of course, well, the impact was to dissuade people from funding illegal activity. Thank you. You've heard Mr. McKillip's answers to my questions during the previous round of questions. He said that there were about 9,000 STRs, suspicious transaction reports. About 9,000 are received per week from financial institutions, among others, and that's throughout the year. I did the calculation. That's 400,000 to 500,000 per year, STRs. And out of those transactions, there are about 2,000 per year sent to the RCMP as being of a serious nature. And during the period of the order, those 8 days, it was the same rate. So should I understand, Ms. Jacques, given that information, that there wasn't really an impact for detecting suspicious transaction reports to fund breaking of the law? So there wasn't really any after the order. There's just your reason that it was so that people would leave Parliament Hill. That's really the only reason at the end of the day, once we have the explanations that were given. Am I correct? I don't think we can reach that conclusion because the 2,000 one disclosure can contain several thousand STRs, if I've understood my colleague correctly. But it was doing the STRs were sufficient, the ones that are always reported. There's not necessarily a link between the STR and the freezing of an account. So I don't see the link between the two. Thank you, Ms. Jacques.
Merci.
Pass the chair over to Senator Boniface for my 5-minute round.
Mr. Green, you can proceed. You have 5 minutes.
Thank you very much. Through you to Ms. Jacques. Ms. Jacques, I believe I heard in your earlier testimony that your department was not conducting an internal review. Is that correct?
Of the activities and not currently, no.
Of the actions in relation to the temporary special measures, there's been no reflection given the gravity of...
No, there's been reflection. I mean, as you've heard with respect to adding crowdfunding platforms and payment service providers, that situation has been now implemented permanently, as we've announced previously. I mean, we have regulations in place.
I heard in your testimony that you specifically did not provide economic impact, and I appreciate that. I want to make sure my words are precise here. You may have alluded, based on Senator Boniface's questions, that other people in your department would have been providing this information. Can you share with the committee today, based on your senior management position within the department, who that would have been to provide that information that would have led to the economic features within the Emergency Act order?
In all honesty, I will have to get back to you because I have no knowledge of, at the time, of the analysis that were ongoing, if any. I wouldn't be surprised if there were some analysis, but I'm not able to tell you who would have done any of these analysis at that time.
I'll go further to comment through you, Madam Chair, that I'm going to raise my concerns again. What I'm hearing in testimony is my interpretation of what you've said, and so I'm not attributing to what you meant. I'm just telling you how I interpreted it, is that you were caught 2 days' notice without much briefing in terms of the Department of Justice or others as it relates to the charter. In your position, when you're contemplating legislation, are you ever legislatively required to provide a charter breach analysis on the policies that you enact?
The Department of Justice provides all the advice and the analysis, whether it's constitutional or charter, the charter impact or the legality of the legislation being passed.
So is that something that you're privy to, given your senior position within the department?
When we legislate, certainly if I'm responsible for a certain piece of legislation and
So
we'll
given
receive
this
legal
piece of
advice,
legislation through you, Madam Chair,
yes,
would you have been provided with a charter breach analysis for contemplation?
I
within your
didn't
department?
receive a charter breach analysis, but opinions were provided by the Department of Justice.
Okay, thank you. And so, again, I'm going to go back to what I think our guiding principle is as a committee, which is to be able to provide recommendations based on the special orders, how they were enacted, given the current contemporary context. Would you consider, given the discussions and the obvious confusion around very learned parliamentarians around the role of your department, would you consider providing a review within your department to help guide recommendations that might come out of a committee like this?
That the Department of Finance would do a review that would guide
future contemplation of the Emergency Act using economic measures, yes.
Well, I mean, it's certainly something that could be considered.
Do you not find it strange that given the rarity of this invocation, that this isn't something that's already been put into play by the minister? It just seems to me to be an abrogation of leadership, given the seriousness of this, and I'm somebody who supported it, by the way, for the record, that we have a responsibility to report back to the public how, why, where, when, and what we did, given the severity of the Emergency Act. Would you not agree?
Well, I understand the role of the committee and that this is information that you would like to provide.
So I would like to ask you this. If you were at this committee and you had recommendations to this committee, given the experience that you had, the 2 days notice, the lack of real briefings in terms of where you were going with it, what recommendations would you provide this committee to hopefully help improve future processes for your successors, perhaps, in future instances of an emergency?
Well, this is something I would have to give due consideration. It's not an answer I can provide here during this testimony.
I would like to ask you to do that.
than-
Yes, it is very broad, as were the measures. I would like to ask you to please consider doing that. And in fact, just as an administrative piece, for all members looking to table, I just, as a reminder, to table it through the clerk so that it can be translated and distributed accordingly. That's it. Thank you.
Point of order, Mr. Chair.
I'm not the chair at the moment. It's Ms.
Oh, I'm
Boniface.
sorry, Ms. Bonner. Madam Chair, I would just like to ask if it is relevant to ask an official who is not an elected member of Parliament or a legislature what their recommendations are, given that they are a public servant.
Mr. Green?
Yes, on that point of order, I find that an interesting proposition. Of course it's relevant. Of course we want to ask expert testimony to provide recommendations to this committee. It's something that occurs in every committee that at least I've sat on, and have a hard time finding how the honourable member would not see this as being relevant, given that we are, hopefully going to be providing a fulsome report. I'll go further on that point of order, Madam Chair, to state that I am still very concerned with the lack of systems and principles in place at the highest levels of management within government to provide adequate and clear answers to this committee, quite frankly. So I would argue that this is very relevant.
Madam Chair, if I could explain my point of order further, if I was unclear. The beginning of the question was requesting that a member of the public service imagine themselves as an MP sitting in this committee, and that is the nature of the inappropriateness. But I understand my colleague's response and his interest. We are all interested in making recommendations that it will be useful in this committee, and that is our committee's work.
Mr. Brown?
If I could just point out, I mean, I think it's an interesting point that Mr. Green is raising, but I guess where I might just draw a qualitative difference is the testimony of a departmental civil servant as compared to some of the other witnesses that we're going to hear at this committee. Certainly external stakeholder groups on whatever side of the political spectrum are going to have views about this legislation, but asking a federal civil servant whose raison d'etre is to provide neutral advice at all times to government, but not to opine upon legislative reform, I think that might be traversing a line. So I think that question would be onside vis-a-vis Canadian Civil Liberties Association, picking something hypothetically, but not for a federal civil servant.
Just succinctly, Madam Chair, just on this interesting contradiction of principles here. We did ask a member from the Department of Justice of Finance to provide legal definitions when we had the Department of Justice here that could have done the same. So, I would hope that we would be provided with latitude within this committee, Madam Chair, and I do appreciate you being the chair in this particularly awkward moment. Thank you.
Perhaps what we can do is the witness has the request, and the minister will be appearing from Finance, and we can make a similar request through the Minister of Finance to get the material.
Good. Return, and I will provide Senator Boniface. You have the floor with 5 minutes.
Thank you very much, Mr. Chair. Just for your benefit, I may not take the full 5 minutes, but I'd just like a little more clarity, and I'm sorry I don't recall who responded about what the issues of cryptocurrency, how that changed or may change in the future. I'm thinking more about the future, not this incident, particularly how that may change some of the considerations from a finance perspective and how the law sits with that. I think it was led by Mr. Fratan's question. Perhaps we can go to FinTrack.
Yeah, let my colleague at FinTrack maybe speak to the specifics of their oversight, and we can speak to sort of a higher level sort of crypto policy.
Thank you.
Right. So monitoring virtual currencies is part of what we do in terms of the compliance function and ensuring that that we have oversight. It's relatively new. It came into force June 2020. So we are conducting some examinations to take a look at how reporting entities comply and how they report on crypto and virtual currencies.
And I'll just add briefly in terms of policy going forward. You might have noted in Budget 2022 that the government announced that it'd be undertaking a financial sector policy review, and part of that policy review is going to be targeted at the future of money and looking at the sort of crypto specifically, and sort of what the policy issues that give rise in the context of crypto, and what positions the government of Canada should take in that regard.
Okay.
And I would also, sorry.
Please do.
I was going to say, I would also add that certainly the event that occurred lead us to wonder how those cryptocurrencies are used to fund illegal activities. So that's something that became clear during these events.
And I'm almost loath to open this subject again, but in terms of internal review, from FinTrack's perspective, how would you normally do an internal review of a particular week of unusual activity or such like. And I'll give you the context. If policing's generally, it's my background, if you're generally involved in an incident, you would have an automatic review that would take place to look at all the steps that we're taking and what may or may not work in the future. Would you normally build that in? And I fully appreciate some of these ongoing processes may inhibit the willingness to do that.
Well, the review was simply, for us, it's how agile can we be? How can we move quickly and reallocate resources quickly? How can we adapt our technology to search for particular keywords, for example, in suspicious transactions and those kinds of things? So, yes, it was almost like a unicorn event, but it was, in fact, it wasn't new for us in intelligence that we'd have to focus on something. We had the same thing with sanctions. We've had the same things with other events that have happened in the past where we simply moved the resources, and if we need to, we would go 24/7 depending on what the event was. If it were a terrorist financing or a terrorist event taking place either in Canada or somewhere in one of our neighboring countries or our Five Eyes, we would end up going 24/7. So we have done this before. And the review there wasn't an official review. We simply adapted processes and approaches that we have used in the past that have proven to be very successful. And I'm sure we'll continue to be successful in the future as we move forward. In terms of the suspicious transaction reporting, it was essentially the same type of analysis and review, albeit we would have to make sure that there was, applying our threshold appropriately and ensuring that there's no simply defensive reporting being filed. But we do that on a regular basis anyway, and we'll continue to do that going forward.
Okay, thank you. Thank you, Mr. Chair.
And before we go on to the next round, I'll ask Monsieur Fortin if you could take the chair for this last round, or Senator Boniface.
Keep him honest.
Keep him honest. Okay, I'll do that. Do you have a timer?
Oui, vous voulez...
Yes. Why do you want me? Because, okay, I can do it. Okay, who are we at now? Mr. White, perhaps? Senator Carignan, you have the floor. Thank you, dear colleague from the Laurentians. My question is for Ms. Jacques. Can you tell us a little about the bank's reaction? Our friends in the banking world say they weren't very happy, that the directions weren't clear, and so there had to be discussions with the government to try to find clarification, to have guidelines on how to implement this order to freeze accounts. Could you discuss that situation for us? Listen, I know this situation took people a little bit by surprise, given that nobody was familiar with the order before having read it. So very proactively, we communicated with different financial institutions. We answered their questions to try to ensure that there was a good understanding of the implementation, to try to answer their questions. We didn't publish guidelines. The financial institutions were legally responsible for implementing the order, but we did everything we could to answer their questions. We had regular discussions with many of them during the situation, and some of our colleagues really appreciated those discussions to try to help them as much as possible, understanding that there were limits because we weren't responsible for implementing that order. What were the main questions, the main topics, the topics raised most often by banks? I think banks wanted to understand the information that would be shared by the RCMP, so I know they had discussions with them. We weren't involved in those discussions. They also wanted to be reassured that there wouldn't be a negative impact, that they would do what they could to do the review, and they certainly wanted to ensure that they were following the order as written and that it would be the implementation of the order. And what are the negative impacts that they would fear? Well, they wanted to ensure that if they missed something, we told them that they had to go ahead with their risk assessment. We didn't expect it to be every person targeted. If they missed a few people when they did their assessment, there wouldn't be any negative consequences. So it was up to them to do their assessment with the information they received, also based on the information they could find using their own software. Beyond the guidelines that you say you didn't have, were there written exchanges with the banks? There were no guidelines. They certainly submitted reports, as I mentioned earlier, but aside from that, I don't think so. I see my colleague. Could you verify if there were written exchanges? Yes, I can verify. With the institutions covered by the order? And can you send us a copy of those exchanges? Yes. And I'll turn to Mr. Brazeau. Other than disclosures regarding the number of accounts that were frozen or requests for meetings, there was no exchange of written information. Are there notes that were taken during those meetings? We can look into it, see if there were notes that were taken, but it was really just discussions, daily discussions. So if there are any written notes, we can have a copy. We can look into what we have, and we'll work with the Privy Council on any document. But now I'm talking about the Department of Finance, not the Privy Council. In regards to disclosure, we'll go through the processes with the committee to provide information. Thank you.
That's Mr. Senator Cameron.
Oui.
Yeah.
Yep.
We'll take back the chair.
Oui, je vous remets
Yes, I give you back the chair, Mr. Chair.
So graciously covering me there. So we have now concluded that round. We have 5 minutes left.
Monsieur le Président.
Mr. Chair, if you'll allow me, I may have a small point of order before we release the witnesses. May I?
Je voulais
Well, Senator Carignan asked a question to this effect, but I wanted to remind Ms. Jacques the commitment that I asked of her to produce a copy of reports. She said there were about 6 that she received from financial institutions. She said she had to verify if she had the authorization. If she can't provide the reports by next week, let's say, can she confirm in writing that she doesn't have the authorization to do it? And can she tell us who refused it so we can follow up on this issue?
Okay. I believe Ms. Jacques has heard that. I'm unclear in terms of where to put it as a point of order. It's direction that you've provided in your testimony. They will do with it as they ought to do. Thank you. But it does provide us a segue. And so at this point, that does conclude the round of questioning for the witness. We will now hopefully try to the best of our ability, deal with where we left off at the last meeting, which was a motion that directed us to have this meeting with these witnesses. But despite our debate, what was actually passed at the last meeting was not a full schedule and commitment, because there was still the question around committee business. And so I guess what we're contemplating now is scheduling for our next meeting and contemplation of any other. I recognize Senator Boniface.
Yeah, it was this is just a suggestion. I understand that we may have some potential witnesses for next week. I'm wondering if the clerk can confirm we have some availability. I wonder if we would be best to hear those witnesses and then set aside the following week, because those witnesses, some of the testimony attaches back to what we heard from the 2 ministers. It's just a suggestion I make.
The suggestion is noted, and so I think for the purpose and the clarity of committee, I'll ask Madam Clerk if you could provide us with if there's been any potential availability made.
Just out of courtesy, maybe we can release the witnesses that we have
Certainly,
here.
yes. Yeah, thank you very much to the witnesses. Again, please don't mistake some of our terseness with anything personal. We appreciate you being here before us tonight, and certainly look forward to working with you in the future. Thank you.
Thank you and have a good evening.
Good evening.
Merci, bonsoir.
Thank you. Have a good evening.
Madam Clerk, if you could comment on the availability of potential witnesses for the next meeting.
Thank you, Mr. Chair. I can't comment with full certitude on the availability, but I do believe that that within the groupings that you discussed last week, we could find at least one of those groups of 2 or 3 organizations to make themselves available for next week.
We have, so I'm going to recognize the speakers lists as Motts, Bendia, and Brock. So we have, first of all, Senator Boniface, does that satisfy your question?
Well, I just wonder if we can clarify what groups we're talking about. I believe one of them's the RCMP. If I'm wrong, please correct me. Yes, it is.
There's 3 hours.
Mm-hmm.
Easy.
So we will now go on to Mr. Motts.
Thank you very much, Chair. A couple things. First, Madam Clerk, we don't have clarity on who's going to be here. No one's committed to next week yet, have they?
That's correct, but only because we haven't confirmed anybody for next week.
Right. So we called for this week. We had Finance Department, and I think, Mr. Green, you alluded to it. The Finance Department, these individuals obviously were financial sector policy branch. The Finance Department writes our budgets, for Pete's sake. And they have not provided us with, these were not relevant witnesses to ask the questions, to answer the questions related to the economic impact. In fairness to Ms. Jacques, that was not their forte. That's not their area. So we obviously need additional witnesses from finance. Clearly we do. And we need some clarity around the clerk who was trying to get witnesses for this week obviously contacted as many as he could, and when he found a stream that was going to attend, or able to attend, I'm sure he pursued those with a bit more vigor. So we really don't know who's available next week, if anyone. And so I would always ask that as a committee, we keep in mind that we do have a number of issues of committee business that we need to deal with yet. And so, as much as we like to get at the witnesses, we also need to finish some other issues off. And if we can't find any witnesses for next week, save maybe one organization for the hour and a half, that we set aside the other portion of the committee for committee business.
You want to note, just for the information of the general information of the committee, I just want to reference the work plan that was submitted to us by the analysts, which does provide a framework that is reflective of our conversation. So I don't want to also negate that. I just want to put that there, and I appreciate them for that work. We have Mr. Motts, is that you concluding your comments? Ms. Bendayan?
Thank you, Mr. Chair. It is my understanding that officials from Justice, that the RCMP and CSIS have confirmed and relayed their availability. Perhaps it was to the estimable clerk, Cardinia, but that is my understanding. I think that was also reflected in the work plan. I would like at this time to move a motion. I move that the committee invite the Department of Justice, the Royal Canadian Mounted Police, and the Canadian Security Intelligence Service to appear at the committee for next week. I believe the date is May 10th.
Okay, so we now have a motion that has been put on the floor. With that being said, we have still a speakers list of Brock, and now I see Senator White as well. Mr. Brock? First of all, sorry, Madam Ms. Bendayan, does that conclude your remarks, or do you want to speak to that in any way?
Perhaps I would just clarify that as per usual, and given that these will be our witnesses, I would add to the motion or simply note that they should come for a period of 3 hours. That does conclude my comments. I would just refer the committee members back to our lengthy discussion about the necessity of these witnesses. I don't think there is any merit in returning to the arguments made at that time.
Thank you. We'll have Mr. Brock.
Thank you, Mr. Chair. And to my colleague, Ms. Bendayan's remarks, I wanted clarity as to which groups we were looking at. So through the clerk responding to Senator Boniface and Ms. Bendayan's clarification, that answered that question. But I have some serious concerns about that particular group. That is a very heavy group. The RCMP, in my view, should be looking at a block of an hour and a half.
No, all 3 hours.
Or possibly all 3 hours.
Absolutely.
The RCMP is intertwined throughout the invocation of the act, the execution of the act, the consequences that flow from that act. So I think to do this committee justice, to ensure that all of our answers, all of our questions are responded to appropriately, that would be my suggestion, and I would be seeking an amendment to Ms. Bendayan's motion along those lines.
It just respectfully, Mr. Brock, can you please articulate what those lines exactly are?
That if the RCMP agrees to attend for next week, that they be the only witness, officials from the RCMP be the only witnesses to appear for a full 3 hours.
We have a speakers list, including Senator White, and then we'll follow up with Mr. Varani, and then we'll go with Mr. Fortin. Senator White, the floor is yours.
Thank you very much. And respectfully, my perspective on the RCMP is that having the RCMP without CSIS at the same time will find us wavering on responses that we will be trying to pursue. So if we're going to do this, I would like to see us with both of those agencies at the same time for the full 3 hours. I'm fine. The second piece, though, I'm more concerned about the who, not the what organization. I don't want to see an assistant commissioner, chief superintendent floating in here. The commissioner, the deputy commissioners responsible for federal services, I want to see high-level officials. I don't think it's fair to the witnesses that they are unable to necessarily respond to some of the questions that we're going to ask. And I don't want to be bringing them back a third and fourth time because we had the wrong people. So it's great to invite them. I think we should be very clear on the level we expect to see as well, Mr. Chair.
So procedurally, just so that I'm clear, because there's no friendly amendments, are you moving a...
I would like to suggest, honestly, and it can be informal if you wish, but my perspective is to have the RCMP without CSIS in relation to this. We will miss pieces, and I don't want to find us missing pieces. That's all. It's for me, the full 3 hours, we will eat it up with both of them, and I think it would be helpful to all of us to have both here answering questions.
So in procedural fairness, Mr. Brock, are you okay to withdraw your amendment?
I'm okay to withdraw my amendment as it relates to the only, to the RCMP appearing as the only witness for 3 hours.
Correct.
In light of Senator White's comments.
And then, just so that I'm clear, Madam Clerk, does it require us to have an amendment with specificity to ensure that it's the commissioners and...
My perspective is that the clerk needs to make it very clear that the witnesses presented are at the highest level, deputy commissioner,
Correct.
Commissioner, CSIS director, deputy director, not
So
finding
my
us-
question through to the clerk was, does that require an
What's that?
amendment?
The commissioner can.
So
She has
there's
to
now an amendment on the floor moved by Senator White, as he's just expressed. Do we have any dissenting voices to that amendment?
I would propose a friendly amendment. Inaudible. I understand Senator White's concern, and I had exactly the same one. Perhaps what we could do is that simply when we invite people, we could indicate that the people who would come here to represent the RCMP has all of the authorizations necessary to answer all of our questions, to produce the documents we will request. I think we can include that in our motion, that it's someone who's authorized to answer questions and produce documents.
I believe I was on your speaking list, Mr.
You
Mayor.
are certainly on the speaker's list, and I would state that my apologies.
It's okay. So I'm being patient here, but Ms. Bendayan actually jokingly referred to Arif, grab out your piece of paper. So this is the original thing we talked about 3 weeks ago, and these are my annotations where we grouped these groups intentionally and deliberately. And then I read them very slowly for the clerk so that they could record them. And ergo, lo and behold, they appear in the work plan. So the notion that we are revisiting instructions we've already given to the fine people assisting us on this committee is, I think, probably frustrating for them, but they're too polite to say so. And I think probably frustrating for me, at least, because we've already decided this. So the groupings that you have on the sheet, independent of the fact that dates have been inverted on one or two of them, are such that we've already agreed to them. And I have no problems with what Mr. White and I think what Mr. Fortin is saying about ensuring that these are of high enough caliber individuals to provide responses and to take things under advisement or undertake to provide answers, etc. But the notion of revisiting the groupings is, I think, probably inefficient, and I'm being polite in my terms of choice of language there, but I think we should just stick with what we've already decided. We can play with who arrives on which date, perhaps, but let's stick with the groupings with the proviso that Senator White has suggested, that we don't have low-level officials from various groupings, but we have the most senior person possible.
Thank you for providing that direction. I will state that I was referencing the blues in terms of what was actually recorded in the blues as a result of our discussion, which led this conversation to be opened up. So while your notes are good, they're certainly not the blues, and I do appreciate that. Mr. Fair enough. We're going to go Mr. Motz, then we're going to go back to Senator White.
Thank you, Chair. With all due respect to Mr. Varani, a committee can change its instructions at any time. I think we would be foolish if we, as a committee, to disregard the evidence we have heard to date and suggest that shooting in the dark 3 weeks ago or a month ago of developing what we thought were reasonable silos of having witnesses now has become very clear that may not have been the wisest choice. And so now we have an opportunity to be prudent and efficient along the way. Having witnesses come here, 3 blocks of them, who may not be able to answer questions as fully as we need, because the RCMP are going to be like a committee a day by themselves at least, and then we have to bring them back 2 or 3 times because I'm not satisfied we're going to get even if it was only the RCMP and CSIS by themselves in one 3-hour setting, that we're going to have enough time to deal with everything as Mr. Green indicated previously. So what that we have a work plan? We haven't accepted it. So what that we made a decision to do this 3 weeks or a month ago? We've got new information. We need to act and be nimble to be flexible accordingly, and away we go.
Actually debating something we might have agreement on anyways. So I'll go to Senator White and look to his collective wisdom to guide us.
I wish it was that easy. Thank you, Mr. Chair, though. Look, the reality is we ask at the highest level. They will bring an entourage with them who we may or may not have responses. I'm not worried about them not having the operational responses. Commissioner Lucky will bring 1 or 2 deputies and maybe an ACOM with her, and I'm sure between them they'll figure out what we're asking and the responses we're looking for. So my perspective is just to get 2 people on the books at the highest level, so we're not finding ourselves a little bit tonight, I felt, with the exception of the ADM, I felt a little lower level than I would have anticipated seeing from these groups. That's all, if I may.
Thank you very much, and I appreciate everybody's insight. I think I want to make sure I'm reading the room right, that we are going to have an agreement to have both the RCMP and CSIS at the next meeting, asking for the highest level of commissioners and officers available. Monsieur Fortin.
Oui, j'avais demandé la parole.
Yes, I had asked the floor earlier. Before we make the decision on next week, I'd like to speak.
In skipping Mr. Varani, I thought your intervention had occurred, so please.
Non, c'était simplement.
It's just that I wanted to collaborate with Mr. Motz. What I wanted to say, Mr. Chair, thank you, is that, how may I say it? I deplore that if we continue in this vein, I don't know when we will ask the government to produce documents that we want. Clearly, it would be in the middle of the summer that we would receive them. We'll all be on vacation, and I don't see why we wouldn't do it now. I think next week, it should have been today, in my opinion. We decided last week that today we needed to hear from witnesses. It was urgent. Finally, they couldn't come. We heard from others. And now we're pushing back the urgent ones. So we're just pushing things back. We need to make a decision on the motions that were suspended. We can add them. I'll give my opinion on the motions when we debate them. But we need to reject them or adopt them. I think we should do it now. We had an issue earlier with our witnesses who were telling us that they couldn't answer certain questions or commit to producing documents. If we'd had the legal advisor we said we'd hire, we could have resolved that quickly. Once again, I think we should reject or adopt those motions. I think we need to deal with that now. And I suggest that next week, the priority be that we would debate the suspended motions and then look at what witnesses we would be hearing and when.
Thank you for that. We now have Ms. Bendayan.
Merci, Monsieur le Président. Je pense...
Thank you, Mr. Chair. I think we're debating the amendment moved. And on that topic, I'd like to say that we agree. I think, Mr. Chair, that if you want to ask colleagues if there's consensus, I understand that there are concerns and that some of my colleagues would like to have just 2 witnesses next week for a 3-hour period, and we would be willing to accept that.
There was a motion on the floor that kind of floated around. We've heard, I think, the urgency to deal with other committee business at the appropriate time. I don't know that this is the appropriate time for that particular debate, given the hour. It is
Mr. Chair, at the very least, my motion is on the floor and it's still the subject matter of this debate.
No, your motion is duly put. Sorry, I wanted to reference the comments by Mr. Fortin in terms of opening up the debate on when we're going to have the committee business. We have...
So you've got an amendment, right?
Yes.
The amendment is first?
Mr. Chair, I could amend my own motion if that is easier, as you wish, if the amendment wasn't properly moved. I am removing justice from my motion.
Let's call the vote.
Agreed.
Are there any dissenting?
What's the motion exactly?
What is the motion?
Okay, if we could just order for a moment.
But next week, because the motion is to hear them next week, I believe.
Order, please. Let's get to the heart of the matter. Madam Bendayan, if you could please repeat your motion.
I move that the committee invite the Royal Canadian Mounted Police and the Canadian Security Intelligence Service to appear at the committee's next meeting for a period of 3 hours.
Just in order to explain to Mr. Fortin, so her motion.
Motion, I do want to reflect, and I'm not trying to overcomplicate things, that before we move the motion in its entirety, do we need direction that it is the officers of the highest responsibility?
My perspective, that's not part of the motion. That's part of the clerk's
Gotcha.
direction. Yeah, that's right.
Okay. So there's a motion that's on the floor. It is open for debate procedurally. There is no calling the question. So if anybody does have input, now is the time. Mr. Motz, followed by Mr. Brock.
Yeah, I just want to go back, and I agree with the amendment. Thank you, Raquel. I want to go back to Mr. Fortin and his the need to deal with community businesses. So I can agree to next week having 3 hours for these witnesses, as the motion indicates. But we have to set aside at least half of a meeting the following week, please, to deal with committee business. Please. We have to.
I think we have consensus around the table on
Good.
that
Thank
informally.
you.
Wow.
Following week.
This is great.
Awesome.
Thank you.
Thank you.
So we do have Mr. Brock, if you want to.
Yeah, just some clarity here. We talked very early on in the process that if witnesses were going to be relying upon any written documentation or statements, that we would try to ensure fairness to committee members, that we're not scrambling at the last minute. We talked about potentially up to 72 hours. So through you, Mr. Chair, a direction to the clerk, wherever possible, if those witnesses will be relying upon written documentation, perhaps a gentle reminder to get it to us perhaps by close of business this Friday as opposed to the day before, would be much appreciated.
Or the day off.
For the day of, yes. Thank you.
That has been duly noted. I want to make sure that everybody understands at this moment, there's a motion on the floor. It has been duly put. We are debating the motion. Are there any other speakers? Huh?
It's a motion as amended.
A motion as amended? Are there any other speakers on the motion as amended?
A point de clarification.
Point of clarification, Mr. Chair. I don't know if in the amendment, maybe I missed it, but during a period of how long?
On parle de 3 heures.
We're talking about 3 hours next week still?
The amendment was to remove the department.
You mentioned, Glenn, it was with respect to the 2 weeks later.
So not for next week, after that we need to set time aside for committees.
And are you
That's not
proposing
part-
all 3 hours?
I don't know. I think half might be enough.
Well, that was my question. Is that part of this motion?
No.
Not this
Thank you.
meeting, the one
so
after that.
can we vote on the motion?
Well, there's still, if people want to speak, they can speak. Mr. Fortin?
Moi, je voulais juste dire que
I just wanted to say that I would have appreciated it being in the same motion, because what I've understood is that we're about to vote in favor of hearing those witnesses next week. Why? Because we've said we will deal with routine motions the following week. Great, but I don't want to be stuck. I want it to be clear to everyone, unless that's not it. But if that's the deal, I think the motion should reflect it and should say that next week we'll hear the two RCMP and CSIS, and the following week we'd have the routine motions.
I would like to.
ah ben, le temps que ça prend,
However long it takes, we could put them on the agenda on the 17th, not the next one, but the following one. And if next week we conclude that we can deal with it in an hour or two, we can add witnesses, but that's a priority. We need to get through that before hearing from other witnesses. Otherwise, we'll end up receiving documents in July, and that won't please anyone.
Mr. Fortin, I want to make sure that there's procedural fairness around the committee. We've heard your request, and I'm going to ask you to clarify, are you moving an amendment?
oui, Monsieur le Président.
Yes, Mr. Chair.
An amendment on the floor that would include the following week be set aside time for committee business. Is there anybody who would like to speak to the amendment that is on the floor?
Time for committee business on May 17th.
The date is May 17th. We will now call the vote unless there's any other input on that. Madam Clerk, if we could please call the vote.
No, everyone.
Everybody agrees. Oh, hallelujah. Okay, that's passed. We will now go to the motion as amended. Agreed unanimously. Let the record show. Did you say on division? Not unanimously. Oh man. Ms. Pendayan. So just so that I'm clear, the motion is passed unanimously? Thank you. And-
Motion to adjourn, Mr. Chair.
The meeting is adjourned.